I believe everyone is back, so we're going to continue. We're going to start with Mr. Hicks. You're going to need to swear in Mr. Caraway.
You swear affirm to tell the truth, the whole truth, and nothing but the truth?
Okay. Oh, I'm Mr. O'Brien.
Yeah, Madam Chair, just for the record, I noticed that Commissioner Tavares is not present, and
She had a conflict and she was not able to make today's meeting.
okay, at least, how does the commission usually handle that, since she's heard everything up till now?
She's heard everything up to this point. We'll see how things develop, is the best I can tell you at this point. We have at times, now that, especially now that we're videoing, she could presumably watch the video, potentially get a transcript and participate if that becomes necessary. We'll just have to, at this point, I'm planning on playing it by ear and seeing how things progress.
Okay, that's acceptable. I just wanted to raise it. Thank you.
Is that acceptable with you, Mr. Hicks?
Well, I know that your rule, that 3517-1-06C1 is that either hearings will be before the full commission or before a panel. So I'm kind of confused right now because there's no, per se, alternate for her that listened up to this point. He's the Republican alternate.
That's correct.
So there's that, so we have an unbalanced. I also believe that probably your own rules, when you talk about like the fine schedules that are in your rules, should have never been updated to reflect the statutory addition of alternates. So they only assume there's a commission, not that there's also alternates. So the play it by ear is a little, I know, shaky to me, but I don't know if you've ever had an opinion before on what happens in this situation, other than play it by ear. I'm sure there's not a documented opinion that says play it by ear.
I mean, it is still a quorum, so
Right.
I think that's how we've always operated, as long as there's a quorum. And there is present today, so I think that's,
We proceed, yes.
we proceed, yeah.
All right.
It's been unfortunate, but it has occurred in the past where we've had hearings that have had persons participate and subsequently not be able to. We try to avoid that, obviously, but sometimes it doesn't become possible to avoid it.
So at this point, we're going to have Mr. Hicks start.
So, Mr. Caraway, just for clarification, I was reviewing your testimony from before, back in September. Can you just break down, because I was a little confused on your time in the 2020 primary, what percent would you say was spent with Schmidt versus with Freeman versus with all the other candidates? Because I believe your testimony was, those were your two main ones, and then there were others, but.
Yeah, I had others, and I'm sorry, Mr. Hicks, I am not at this point going to guess or try to quantify. I had many candidates, both House candidates, county candidates, and so it wouldn't be fair for me, particularly almost 4 years after the election, to try to guess. Sorry, just not going to do it.
But you already testified for a percentage.
So whatever I testified at.
Do you remember what you testified?
I don't, I'm sorry.
Okay, I think, would you be, would you disagree that the record would show that you testified to 50% or more with those two candidates?
That's fine.
And just because of what you said there, were you compensated by JPL and Associates for working with county commissioners or county candidates, or only for state rep candidates? You just mentioned county commissioners.
Yeah, so I build county candidates through my company, so.
Okay, I'm just talking about the time that was your JPL,
Yeah.
State race time. So, so you would, that path, assuming I remember it correctly, the 50% would not be off the mark.
Sure,
Okay.
not unreasonable.
And beyond, if you had to generally quantify state rep candidates, because remember you said south of 70, other than Schmidt and Freeman, how many other state, just order of magnitude, how many other state rep candidates were you working with?
8 to 10 to 12.
So you were working with, if I use the low number, 10 total, including Schmidt, Freeman, and 8. or 14 total if I took the high number. So somewhere between 10 and 14 total candidates, in which 2 were Schmidt and Freeman, is that?
Yes.
Okay. For the other candidates, was your time with them fairly evenly distributed?
I would think so. Obviously, campaigns ebb and flow. So
Okay.
1 week, you may spend a lot more time on another.
So just so I'm clear to your testimony, so if you had 2 candidates were a lot of time, and then you had candidates that were fairly even at the next tier, it wasn't as if there was a 3 tier, like there was high, medium, low. It was just, there was high and there were other. Is that a fair representation?
Yes.
Okay. In that blue notebook, well, I'm gonna refer you to something in there. And Mr. Richter, I'm assuming that the commissioners have a copy of Exhibit S. Okay, so
Exhibit S, so that's
the one I saw a week ago? The new one?
the mailers, yeah, I sent those to the
Okay.
commissioners.
So before we look, we're gonna look at Exhibit X, S. What was your role, if any, in the approval, the design or approval of mailers for candidates?
Can you tell me what page that's on?
Well, I'm asking a question before we look at the exhibit. So I just want to make sure you hear my question.
Mostly limited. I don't remember handling much creative at all.
Were you part of any sort of approval cycle for any candidates for
The
mailers
approval
or
process was not part of my wheelhouse.
Okay. I observed in the Alan Freeman case, which there's an exhibit of some of those in there, you were never copied on mailers. It was Megan Fitzmartin and Alan Freeman who were going back and forth. Is that your recollection?
Yeah,
Where some of that came
Yeah, I
from?
don't want to say I was never copied, but certainly that was not something I took care of.
Okay. And then, so just for the record, that was the emails about Freeman, approvals for Freeman mailers was Exhibit F, okay? And I don't believe you were ever copied on any of those in there, but your testimony would be if you were, that you were not a part of the approval cycle. Is that a correct statement? You were not a part of the approval cycle for mailers?
Correct.
Okay. So I want to direct you to, in that book, there's another one of my hillbilly tabs off of the P-Touch that says 1026. And for the commission, that's Exhibit S. S is in Sam, and it's a bunch of mailers.
Okay.
Are you familiar with any of those mailers? You recall any of them in particular? Were involved with approving any of them?
The coronavirus resource guide, I remember that, but only because it was certainly a unique mailer. None of these really, I can remember specifically.
Did you typically, just for benefit of the commission, did you typically receive mailers from Gene Schmidt, as a voter?
No,
No.
I'm not in the district.
And because you're not in her district, okay? Okay, so down in the, if we look at the first page of Exhibit S, down in the very bottom right corner of that page, there's a number, and I can barely read it. Can you read that number?
You'll have to direct me to exactly what page is
The very first exhibit, the very first page of Exhibit S,
Okay.
at the bottom right corner, there's real small down there, there's a number. Can you read that
I
number?
can see a line. I'm sorry, I have a disease.
Okay.
Sorry.
I have
But I can see
the old age, but I'm discovering readers or cheaters or what have you. Okay, so you can't read that number down,
I can see a line.
that there's a number down
Want me
there?
to put the book up to my,
No, it's okay. I can read it and it says 20-OH-SCH-001P. Assuming that I just read it correctly, which I think I did. Are you familiar with those kind of numbers or the meanings of those numbers?
I am not. Obviously, SCH would be, the first three letters of Representative Schmidt's name. But and 20 would have been the election year. But different folks have different ways of coding mailers. Sometimes I've seen them coded, sometimes not.
Okay. So when you go to, it's actually redundant. I don't know if this is important, but because I don't think I have much of any other questions for you. But just in the back of that, if you go back and exhibit S.
S?
Yeah, the same one. There's a bunch of pages there, they're all mailers. And then at some point, there's a letter. It's behind all the actual, colorful mailers. There's a letter dated March 31st, 2020.
Okay.
I think on the page, it's page number 15 on the exhibit that I provided. Are you familiar with that letter?
Had not seen it before, but knew it existed.
Okay. And, you see that letter is from Jennifer Black. Do you know who Jennifer Black is? And if so, could you describe who that is to the commission?
Yes, it's Representative Schmidt's sister.
Okay. And I'm going to ask you to just flip forward one more page. And this is, it's another exhibit number. It's one of Mr. O'Brien's exhibits, but I put it here also. This is the invoice the Goldstein / constant content invoice. You see those, can you read those numbers on there?
Yes.
Did you see, would you agree that the number I read, which was 20-OH-SCH-001P appears on this invoice?
Could you say the last three digits again, please?
20-OH-SCH-001P.
1P does show up.
Okay. So had you before, I can't remember what your prior testimony is, so it's my, but did you look at with Ms. Schmidt her invoices like this constant content invoice?
I'm not sure. There was a lot of invoices that came in around August or September of 2021 from many members. And so I can't recollect if I'd actually seen this one, but I'm certainly familiar with the format.
Okay, that would include being familiar with the type of numbering that shows up in these invoices, is the descriptions?
Yeah, well, yes.
That you've seen that in other invoices, that syntax. So, there's somewhere in here is an invoice that is the $164,000 invoice. I think it's respondent exhibit number 11. By the way, I provided Chris, for the commission members, I provided Chris an updated PDF file with bookmarks that have all the things in there.
Under what, Mr.
So this is going to be in the back. The very back is the respondent exhibits. See where there's a little paper tab that says RESP. So it's Mr. O'Brien's exhibit.
Yes, I see it.
Okay, and then it is back there. If you find exhibit 11, if you see that the total is $164,334.31, then you found the right page.
Correct.
Okay. Are you familiar with this invoice?
I knew obviously it existed. I don't know that I'd actually seen it, but.
Okay. Did you see these kind of invoices involving other candidates with which you work?
No, not until a long period after the election, and Mr. Goldstein's firm was involved.
Well, so this
Sometime
invoice
2021.
was predates Mr. Goldstein's
Okay.
firm
Yeah,
involvement. It's just a constant content
I
invoice.
wouldn't have There's an overwhelming chance that I would not have seen this before.
Okay. The 8 to, what was it, 8 to 10, 8 to 12 maybe you said, candidates other than Schmidt and Freeman, were you aware of them getting invoices from Constant Content? Any, some, all, none of them?
I'm sure multiple ones would have.
Okay, okay. I think that's all the questions I have for you.
Good morning, Mr. Caraway.
Good morning, Mr. O'Brien.
You can put it there.
You indicated in response to one of Mr. Hicks's questions that you were involved in county candidate campaigns in 2020 in the primary, is that correct?
Correct.
And you said you had your own consulting business?
That, yes,
Is that a campaign consulting business?
correct.
Throughout these proceedings, we've heard about a term of plussing up, and at least at the last hearing, as shown in Schmidt's exhibits, I believe 11, I went through a process of comparing the bills from strategic media that showed on a photo shoot, that on radio production and airtime, and on TV production and airtime, that there was a 10% markup by Constant Content. Were you aware that Constant Content, when you worked for them, was doing that?
Mr. O'Brien, I was not. I would have assumed they would have because that's what.
Object. I don't believe it's an evidence that Constant Content was doing that. He made a statement that they were doing that in some way, referencing him, implying that it was for him.
No, my question, I think, was, were you aware that Constant Content's invoices to Ms. Schmidt and others had a 10% markup? And I think he said, no, he was not.
Object. We don't know that they did for others either.
But that's his answer. I mean,
Yeah, but the question is the issue. The question is introducing as fact something that's not in evidence as being a fact. He's making a statement that invoices other than the ones that he presented have been marked up by 10% for other candidates. That's not something in evidence.
I'll withdraw the question and restate it. Were you aware that Ms. Schmidt got a 10% marked up invoice?
Not at the time, certainly am now.
Have you looked at the invoices from the exhibits in Respondents Exhibit 11? If you could look at that.
Mr. O'Brien, what, is it in the back? Or?
Yeah, it's toward the back of Mr. Hicks's most, I think they're right in front of S.
Okay. What page? I'm sorry, what exhibit?
I think they would commence on 11A. I don't see a page marked at the bottom to tell the truth there. It looks like they're if I can try to find it for you when I approach the witness. I don't see that they're in there.
Which exhibit are you looking for?
Looking for the Schmidt's Exhibit 11.
It's in there. If it's mine, if he's looking at my book, it's in there. Under respondent exhibits, and then just look for the numbers, they're not there.
Okay.
Okay.
Oh, Respondents Exhibit 11 and 11 series thereafter lists, in the first instance, Exhibit 11 is the exhibit for 164,33431 that lists a number of items, a photo shoot, cable airtime, chaser, media production, and so forth. If you look at 11A,
Okay.
that references some strategic media placement invoices from February 21st to 20, the radio airtime was 23,560, radio production 550, and the total invoice 24,110. And Exhibit 11 from Constant Content, that is marked up 10%. Does that appear to be the case?
What line is that, Mr. O'Brien, on the bill?
Well, 11 is photo shoot at the top of the bill,
Okay.
is 1650, and it was billed 1,500 in 11C.
Yes,
You see that?
I do.
Okay, and if we go through the radio production, there's a similar 10% markup, and the TV, similarly, a 10% markup. Do you see those?
I do.
And I think my question previously was you were not aware that there was a 10% markup being invoiced to Ms. Schmidt by Constant Content, correct?
Correct.
In your campaign consulting business, do you mark things up like that in services you provide your clients?
Always.
And can the number vary?
Very much so. For example, small volume, a county race, for example, you'll see the markup much, much higher because the volume isn't there to make it worth the consultant's time. But in a race where there is a lot of volume, oftentimes the percentage, or at least my percentage, just went down.
And what's the markup designed to cover for the campaign consultant, whether it's you or Mr. Longstrap?
Overhead, staff, strategic decisions, right design, mail, print, whatever is, obviously a campaign has messaging. The messaging needs to match, whether it's on a mailer, television, whatever. And so all of that infrastructure is paid for by a markup.
From the hard price of whether it's a photo shoot, radio or TV.
Correct.
And is that standard in campaign consulting business?
Yes, some consultants do it a different way and charge a monthly retainer. Oftentimes those retainers, they will then white label the product and then up the percentage a smaller amount, but consultants do a flat retainer fee so that they know they had X amount of dollars coming into their business every month. I've just never done it that way.
And tell me what you mean by the term white label.
White labeling, there are some of the best firms, political firms in America, right here in Ohio, for example. And so rather than recreate, I'll use digital advertising as an example, rather than recreate the infrastructure to successfully deliver digital ads, particularly a small shop like mine, I would contract with a larger firm. Oftentimes very, very large firms, they reduce their retail price, for example. So if Mr. O'Brien goes and gets a $10,000 digital buy, I as a consultant may be able to get the same impression count for $7,500. I would assure you that I would then charge you $10,000 to $12,000, for example. So the white labeling is using another firm, white labeling their, it's almost like blind shipping when you're shipping something out and marking up your work through them.
And so if I come to you as a candidate and hire you as my campaign consultant, you do not produce, write the TV ads, and you subcontract it to somebody else, is that?
Correct. Sometimes I would write some material if I Obviously wanted to, make sure messaging was correct with my clients, but certainly most of it is jobbed out.
And at least Ms. Schmidt, in this case, came to Constant Content JPL Associates to be the campaign consultant for her campaign. Is that your understanding?
It is.
And JPL and Constant Content did not produce the TV ads, correct?
Correct.
Yeah, that was strategic media.
Correct. That's correct.
And strategic media then billed Constant Content, who paid the bill, correct?
Correct.
And then Constant Content invoiced Ms. Schmidt and marked it up 10%. Is that accurate?
Based on this material, Mr. Bryan, it is.
And did you, we've heard that you were working on 8 or 10 or more state rep candidates. Since I understand why you may not be able to identify what amount of time you spent on each campaign, 4 years later, or 3.5 years later, did you contemporaneously keep time? Like I made a phone call, or I reviewed an email, or I was involved, even though you weren't in the mailers. Did you keep time on a daily basis?
No, sir, I've never kept time on any political race.
Would that be pretty difficult with 8 to 10 candidates you're working for?
Absolutely.
And is that one of the reasons that the markup is used, as opposed to billing if you spent, an hour and a half a day for a week in the primary period on Ms. Schmidt's campaign, instead of separately billing you at 1.5 hours per day? You didn't do that, correct?
Correct.
And Constant Content gave one bill, which had the 10% markup that covered that. Is that your understanding?
That's my understanding.
Okay. And as you say, that's somewhat normal in the campaign consulting business?
Absolutely.
Okay, and so would it be your understanding and belief that that whatever time you spent on Ms. Schmidt's campaign was paid for through the 10% markup?
I would believe so.
And you would not consider whatever time and whatever value that would be attached to that was an in-kind contribution to her campaign that she didn't report?
Correct.
And would you say that's true for Tommy Rolfe,
Yes.
Megan Fitzmartin?
Objection. This is pure hearsay. Pure hearsay.
Sustained.
Was anyone who was employed by Constant Content for those campaigns, to your knowledge, separately or individually?
Objection. He said he wasn't involved with any of the billing. So it's just asking to get more hearsay.
Sustained.
We've talked, Mr. Caraway, about a fellow named R.J. Mancini. He was not on the payroll of Constant Content, was he?
I believe.
Objection. He doesn't, he was on JPL's payroll. He doesn't actually know who was on Constant Content's payroll.
Well, I think he can answer the question no, then, Mr.
He can, yeah, he can try and answer the question if he's got some information.
I'll withdraw the question, Mr. Caraway. And in terms of an in-kind contribution, how did you, as a campaign consultant, handle advising candidates that you contracted with? Any amounts that should be reported for an in-kind contribution?
So, in my previous jobs, we would have, when a report was due, we would take a look at all the invoices and the spending, and then tabulate, and then we would report that to the candidate and the candidate's campaign committee. Oftentimes it would go right up into the deadline, and so we would send it after they had already filed their report, and they would have to, do an amended report, but the in-kind comes from the political entity or the person that was in-kinding it to a campaign committee.
And the candidate or the campaign committee is specifically notified about the in-kind contribution, correct?
That's correct.
Objection. The he doesn't know, that's just asking for him to testify as to what the law or the rules are. So,
He was
the
speaking
law,
from
the
his
law is not what was just said.
He was speaking from his experience, I think.
And if you know the answer, you can.
I lost you.
I guess the question is, can a candidate report as an in-kind contribution something that they're not aware of and have not been advised by the person who provided it?
They cannot.
If you want to look at Exhibit 11G, it's had a couple emails from some people we've talked about before, Susan Jones and Anna Lippincott. Okay. And do you know who Anna Lippincott is?
What exhibit are we looking at?
11G, George?
Yes, Anna Lippincott was in charge of the financial apparatus of JPL, in-kinds, that kind of thing from 2020.
And tell me who Susan Jones is with the Winterset CPA Group.
Susan Jones is a treasurer that works at Winterset CPA, and if my memory serves me correctly, she was the treasurer of the House Republican Campaign Committee along with some various other candidates.
And is it fair to say that this email chain is Ms. Jones and Ms. Lippincott communicating about what in-kind contributions from ORP should be included on reports to be filed by about 7 or 8 candidates?
I think I want to object because his question was, is it fair to say? Either has personal knowledge that it is or it is not.
But it speaks for itself, Mr. Kerwin. Can you tell me
No, it
if,
doesn't speak for itself. So I have an objection to the phrasing of the question of, is it fair to say? That's an opinion.
I'll withdraw the part that says, is it fair to say, Madam Chair? And I will ask Mr. Caraway, does 11G reflect a request for who should be given in-kind contributions?
It does.
And is there a list of 6 or 7 state rep candidates that Ms. Lippincott, Ms. Jones identified?
Yes, there are 7.
And are you familiar with the names on that list as state rep by candidates in the primary in 20?
Yes, I am.
And is Ms. Schmidt on that list?
She is not.
So Ms. Lippincott for JPL/constant content and Ms. Jones for HRRC are not identifying and notifying Ms. Schmidt that there's an ORP in-kind contribution. Is that correct?
That it would appear so.
Okay.
So what's the question again? Can you read back the question?
Ms. Lippincott for JPL/constant content and Ms. Jones for HRRC are not identifying and notifying Ms. Schmidt that there's no ORP in-kind contribution. Is that correct? That you would yourself.
So I just want to object on many fronts. First, nobody from the ORP has copied on these emails. Second, I'm not aware of Ms. Jones working for the HRCC. So that's not in evidence. She was the campaign treasurer for Mr. Freeman, for example. So there's many things in what Mr. O'Brien just made as a question that are inventing facts, per se, from thin air. So I object to the question entirely.
Sustained.
Does Ms. Jones ask Ms. Lippincott and state at the bottom of 11G, I don't want to prepare someone's report yet if I need to wait on in-kind information. Thank you. Is that at the bottom of the email?
It is.
And does Ms. Lippincott then respond to that inquiry? identifying the subject as ORP in kind.
Yes.
And
Not exact, she just identifies what, she's making a statement as to the future of a list, it's not the list from the ORP.
this is your exhibit, Mr.
No, it isn't, it's yours.
It's mine now, but it was marked previously by you as an exhibit at the May 3rd hearing.
Okay, but what does that have to do with the line right before I object to the question, because it says, but the ORP list will be. It's a speculative note as to what potentially will be on the ORP list. They have not yet received the ORP list based on the document speaking for itself. She's speculating as to who's going to be on the list. She's not,
I'm gonna overrule that because it says what it says.
And at least we don't know, as Mr. Hicks accurately pointed out, what the ORP list was, but this document that is 11G and a similar exhibit from Mr. Hicks states who the list
is there
will
will
be,
be just testifying?
who the list will be, and Ms. Schmidt's not on the list. Is that correct?
Correct.
Okay, thank you, Mr. Caraway. I don't think I have any other questions, Madam Chair.
All right, Mr. Caraway, were you, what was your contractual relationship with any, if any, with Constant Content?
I don't believe I had a contract with Constant Content.
Okay. Have you ever seen a bill from, well, who was your contractual relationship with?
JPL,
And when we say your contractual relationship, the name of your company was what?
Churn Creek Strategies.
Okay, previously in the Alan Freeman case, there were some Churn Creek Strategies invoices in there that were then shown on campaign finance reports. Were they plussed up to your recollection on any of those campaign finance reports?
Those in particular most likely would not have been because of the sales tax provision.
Okay,
So it would have been the responsibility of the end user, the person selling the product to add the 7.25.
but you submitted those invoices, when you had invoices for things like expenses and so forth, as I recall, those were printing invoices, is that your recollection? Okay. You submitted them to JPL and Associates or to Constant Content?
I'm not sure. One of the two, certainly. I want to say Constant Contact, but I'd have to see them.
Okay. So, but your recollection is those invoices were not plussed up? There was no
My
plus up?
invoices would not have been plussed up.
You made reference to working on a monthly retainer. What was your relationship, what was your contractual agreement with JPL and Associates? That you would be paid on a monthly retainer or some other method of payment?
I was on a monthly amount.
So you're on a monthly amount?
Correct.
When you have done your consulting work with other people, like you mentioned county commissioners and stuff like this, have you ever charged them a monthly retainer?
No, rarely could they afford it.
So you've never charged another candidate a monthly retainer?
I'm sure I have at some point, but rarely county candidates. And I know some of my former colleagues in the business did, for example, a few in Cincinnati.
Okay. My wife did work for you doing some mailers, is that correct?
It is.
At some point in time, doing the design work for them. Are you aware of how she was compensated?
I would have written her or her company a check.
Okay. And then you would have invoiced for that to the candidates to which those mail pieces were being created?
I would have marked up her invoice and made it part of a package. So messaging, design, print, spray, USPS drop off.
Okay. Are you, let's look at Exhibit 11. the one that Mr. O'Brien directed you to. It has a $164,000 invoice.
Okay.
And then he has these exhibits 11A and B,
Okay.
which are, have you ever seen those before now?
It is likely that I've seen number 11 on the left of 164, but I can't point to a specific.
I specifically asked about 11A and B.
I don't remember seeing A or B.
Okay. Have you testified before in hearings that you were never asked anything by JPL or Constant Content pursuant to how to allocate your time,
Correct.
okay? Or how to allocate the money involved with your time? Is that a correct statement?
Correct.
Okay, the 11A and B, have you ever seen, if I represented to you that these are documents that Mr. O'Brien created, would you have any reason to object to that, or would Mr. O'Brien object to that?
No.
Okay. Have you ever seen any documents like that from Constant Content, or from JPL, or from Anna Lippincott, or from anybody associated with the 2020 campaign, primary campaign?
You mean this simple document?
Something showing this kind of analysis of how things were marked up?
No. But sir, typically you don't show the client what the markup is.
Okay, so so clients don't want to see the underlying invoices? So,
They don't, that's just not how it works. They get an invoice.
so in my personal experience as a consultant and non-political, people always wanted to see the underlying invoices. There may have been an upcharge, like in the IBM Corporation, we put 10% upcharges was the standard upcharge on invoices that were being passed through. Your clients don't ever want to see the underlying invoices?
I have never had a candidate ask me, you know, hey, they obviously know I'm making money, or my company's making money. I've never had them ask me for a breakdown. And even if they did, I don't know that I would, I mean, if they want to know that kind of information, they could go find another consultant.
So when you were, Churn Creek Consulting was working for JPL and Associates in the 2020 campaign, why then did you submit underlying invoices in the Alan Freeman matter? If nobody ever asked for underlying invoices, why were you submitting underlying invoices in that matter?
So those particular invoices, I believe as I testified in 2021, were for specific printed products. Mr. Freeman was not my client. Mr. Freeman was another firm's client. And so I had my cost for those, and that, you know, JPL Constant Content would have needed to do the proper markup and the sales tax.
Did you ever provide an in-kind statement to any candidate that you worked with for the billing of your time?
There would have been no reason to,
Why not?
because they were paying for a service. As part of products.
Who were they paying?
They were either paying JPL or Constant Contact or.
Well, have you ever seen any invoices of a candidate getting an invoice from JPL and Associates in this matter or any other?
I'm not sure, I haven't seen one.
So in this matter, did Ms. Schmidt, if you look at Exhibit 11, it's the $164,000 invoice, and Exhibit, is it maybe B or C, it relates to what was the $39,000 invoice. I guess was there any invoice that you see in any of this case that's from JPL and Associates to anybody?
I would need some time to review the book, but if you say it is here, I'll take your word for it.
Okay. So when you had, what contractual relationship did you have with Constant Contact?
I was brought on to take care of house races or advise on house races south of Interstate 70.
So your previous testimony is that JPL and Associates hired you to do that, not Constant Contact. Are you refuting your prior testimony?
Ask the question again. I mean, it was JPL, Constant Contact. To me, it was
Well, you
virtually one and the same.
testified
They had the same
previously that
principles.
specifically you worked for JPL and Associates. You were paid by JPL and Associates. You had a
Correct.
contractual agreement with JPL and Associates. And I just asked, what contractual relationship did you have with Constant Contact.
I didn't have a contractual relationship with Constant Contact.
So how would you know that your services were going to be theoretically, based on Mr. O'Brien's creating his own exhibits, somehow
Object
plus
to the
up or
reference,
rebuilt?
Object to the reference.
Sustained.
By what basis would you assume, without you providing an in-kind report or something like that, would you have assumed that your services were going to be in some way rebuilt?
Well, I don't understand why they wouldn't have been.
So why would they have been? You said you worked for JPL and Associates, you were being compensated, you were working for various candidates. In concept, without no connection with that in Constant Contact, you would have had an obligation under the law to provide in-kind reporting to those candidates for your compensated time. Why would you not do that, or what would you? You're the one who testified that that's what you need to do. Is
Yeah, I
provide a
disagree
report.
with you. The companies, whether it be Constant Contact or JPL, have the same principles. They are one and the same as far as I know. I don't know what the contractual relationship between Constant Contact and JPL would have been.
Do you have any personal knowledge of some sort of scheme that involved rebilling your time? Any personal knowledge
I'm not going to answer a question with the word scheme in it.
of any sort of arrangement, any document,
I'm not
any
aware.
discussion that you had, any of that? You're aware of any of that?
I'm not aware.
Okay. So if you look at the Exhibit 11, and I want to just use the round numbers. This is, I'm sorry, to be clear, this is Respondent Exhibit 11. The invoice, you would agree the invoice amount that nobody seems to be disputing on that one, which was paid by Ms. Schmidt, was $164,334.
First page?
Yeah,
Or-
Exhibit 11, it says,
Yeah.
yeah, so the one that says 11,
Correct.
doesn't even know. So $164,334. And would you agree that 10% of that is roughly $16,000?
Correct.
Okay? And then the other exhibit, which I think is it's exhibit. It's exhibit. No, not, it's under the 723. Oh, yeah, it's part of exhibit A. Get confused on it. Which is it's part of the 723 exhibit, but exhibit A, that's the 30, it's like the third page of it, the $39,000 exhibit. You would agree that, you find that exhibit?
This one?
Yeah, if it says 39,000 at the bottom.
Yes.
Okay, so would you agree that 10% of that is 3.9 thousand?
Yes.
Okay, and if you add up, if we just round that up to 4,000 for government work, if you add up 16,000 plus 4,000, then you'd agree that's 20,000?
Yes.
Okay. So, are you aware of it being a common practice in the rebilling of invoices for 10% to just be added as a profit margin? Are you aware of that being common practice? Or?
In political
I
accounts?
think basically in anything involving advertising.
Yeah, I think 10% is, I think it fluctuates, but 10% is a fair number.
And you would agree that, would you agree or disagree that campaigns that do just media and don't have field people to be campaign managers and door knockers and all that kind of stuff, that it would be somewhat customary that if just doing media type things, there would be a 10% markup?
Just television or?
Television and
radio?
mailers and stuff like that.
So are you asking me about broadcasting?
Let me withdraw and ask it more clearly. So you've testified as already just today that you had no involvement or no formal involvement with any sort of creative work or approval of mailers, which are in particular focus here. You know, there's media stuff too that's part of 164. So that you weren't involved in that, in the mailer process, okay? If You know, but you were doing, well, what were you doing then? If you weren't involved in the mailer process, what were your day-to-day activities related to the Schmidt campaign?
Strategy, you know, talking to the candidate, making sure everything was, you know, that the trains were running on time.
What about going to events or anything like that?
I'm object at this point, Madam Chair. This is redirect, I believe, and it's outside the scope of it. And I think we've had Mr. Caraway testify in detail about his.
That has been, you've already gone over.
Mr. O'Brien made a lot of assertions as to Mr. Caraway's expertise and experience and that he was tied in with these invoices. So I think I'm at liberty to explore the connections and what connections any work he did was with the invoices, because that's what Mr. O'Brien just had him answer questions about.
Ask those questions.
I think I was asking.
You seem to be going down to asking to repeat responses that he gave earlier.
Okay, I don't agree, but, all right, in what way?
Because he's been responding about what the nature of his general activity has been.
So I think I'm asking questions still to clarify, because some of his answers to Mr. O'Brien were inconsistent with some of the prior answers he's given. So I just want to make sure to have clear on the record what were the right answers. So he just previously, today, testified he didn't have any involvement with mailers. And then we heard a testimony that somehow he was involved with billings and rebillings of mailers. That he was somehow within those
I don't
activities.
recall hearing any comments about him being involved in rebillings of mailers.
That his services were involved in the rebilling, it were rebilled for, it varied in prices for mailers.
I might say that was other clients, I believe, the testimony.
I don't recall him saying he had any rebilling of mailers.
That he was rebilled within the bills for mailers. His services were being rebilled, buried within the bills for mailers. That's what I'm asking about.
Okay, ask that then, because I'm sorry, go ahead.
Well, I'm asking, I apologize for being redundant, okay, if this is redundant. But just to be clear, you have no personal knowledge or evidence you can provide that there was ever an arrangement involving rebilling your field services costs that had nothing to do with mailers in bills for mailers.
So, repeat the question, I'm sorry.
Do you have any personal knowledge that in any way or any evidence that would show that your time for doing field services unrelated to mailers was somehow rebilled within mailer invoices to Ms. Schmidt?
I don't have personal knowledge.
Okay, so on Exhibit A, the $39,122 invoice,
Okay.
if you also look at Exhibit C, it should just be a couple pages ahead, and that's what was actually paid for that invoice,
Okay.
$20,260.
Yes.
Okay, so that, would you agree that difference is, I don't want to, that difference is about 20,000?
Correct.
I mean, it's less than 20,000, but it's about 20,000. What's 10% of 20,000?
Couple grand.
Okay, so if you were actually for real, somehow being rebilled in bills for mailers, what happened to that 2,000? Would you speculate as to what happened with the $2,000 of that was written off or what have you?
I'm object asking a witness to speculate.
Do you have any personal knowledge of what would have, how that 2,000 that is taken out there at the 10% would have been otherwise rebilled to Ms. Schmidt?
I am aware of how the invoice went from 39,122 to 20,260. But I guess I'm missing the premise of your question on $2,000.
So if you were, let me clarify and then get to a quick question. So if Ms. Schmidt was billed roughly 40,000, I know I'm rounding up, so just for simplicity, and paid 20,000, and if somehow commingled in those bills were field services like, campaign strategy and stuff like this, that would mean that $2,000 was never rebilled because it was written off. Is that correct?
Object, the whole question is premised on speculation, and it's something the witness has already testified about, he was not involved in.
It certainly sounds like a lot of speculation when it comes right down to it.
So would
You
you,
ask something that would be more direct based on personal knowledge.
okay, so I did, I said, based on personal knowledge, would you know what happened to the $2,000 that would have been part of the 10% markup?
I don't know, and I'm certain that Representative Schmidt would have known because she paid the bills that were sent to her.
Okay. You said in your testimony that you talked with Ms. Schmidt about these invoices and these matters, you did testify, to be fair, not until after my complaint, that before that you had not. Would you agree that that was your testimony?
Correct.
After my complaint, and when you did talk to Ms. Schmidt about the invoices and the $39,000 invoice, did you ever talk about that somehow that invoice contained billing for you?
No, we talked about the inconsistent nature of all of the bills and the fact that many across the state of Ohio were incorrect, and that we had asked for Goldstein collectively as the House campaign arm to prove that services were rendered. That was the premise of my discussions with Representative Schmidt.
Okay. And then I think the last thing is Mr. O'Brien is trying to make the case that you were somehow rebilled in the billings for mailers.
I'm object that characterization of what I said or didn't say, or questioned, or
Sustained, I don't think he said that.
I think he had an exhibit and he walked through that was what he was saying was the case. Mr. O'Brien made an exhibit.
I was for
Maybe
photo
that
shoots, radio production, radio time, TV time. I don't believe mailers were included on that, Mr. Hicks. If we look at 11A and 11B.
Okay, so I stand corrected that the speculation by Mr. O'Brien was specific to TV time, TV and radio production.
Object and move to strike the word speculation. It's a mathematical equation based on fact.
The speculation part is that he was somehow included within that mathematical equation. That's the speculation, not that 10% is 10% or 12% is 12%.
That was his testimony, not my speculation.
His testimony was as to the percent. So again, do you have any personal knowledge? See, this is why I don't mean to be redundant. That's why I was wondering, do you have any personal knowledge of that you were somehow incorporated within a 10% markup rebill for your Churn Creek consulting services that were being billed that were being compensated by JPL and Associates? Do you have any personal knowledge of that?
I do not. However, it would be reasonable to believe that.
Okay, but you have no.
Correct.
No. Okay. Do you have any evidence of that? Any contract you had with them? Anything in writing that would say that that was or happening or would happen?
No.
So, did it ever cross your mind that there could be an in-kind issue where you needed, when JP&L was paying you, that you needed to somehow send in-kind notices?
No, it did not.
If there was a testimony about in-kind, if a person did work and was compensated, like say somebody paid, let's say you were running for some office, and somebody paid me to go door knocking for you, and I did not send you a thing, but you are aware of that. You are aware that somebody paid me. Do you have an obligation then, if your understanding of campaign law, that you have an obligation to ascertain what should be billed, what should be shown as an in-kind? Or you can just, or you don't have any obligation to do that even if you're aware of the activity?
You have reasonable expectations to try and ascertain. In this case, the campaign committee had paid tens of thousands of dollars for services. So there wouldn't have been any reason to ask, in my humble
Okay.
opinion.
So I think very last thing related directly to what Mr. O'Brien asked is he directed you to look at exhibit 11G, and I'll direct you to look at that as well.
Is it in the back?
Yeah, it's the what you were looking at when he was, it's those emails.
Oh, okay.
Was,
Wait, hold it just a second, please.
it's gonna be the ones that his exhibit tags look very different than mine, so it's gonna be towards the back of that last tab, 11G.
Okay.
So,
Sorry.
we're getting close, I think. It's almost at the very end, Steve, like the
Okay.
last three.
Okay, all right. Okay, oh, this email?
Yeah, but it starts on the page before that. It's like just on the very bottom of the page
Okay,
before.
I see it.
So, who did R.J. Mancini work for, to your knowledge, to your personal knowledge?
I am now aware that you work for the Ohio Republican Party.
I mean, in the field, when you were,
I'm sorry.
you know, you testified, he was involved in
Yeah.
some meetings on campaigns and stuff
Sure.
with you. Who was he working for from a candidate perspective?
He was assigned to Mr. Freeman.
Okay, and you would say that he spent a significant percentage of his time with Mr. Freeman?
Yes.
Do you believe, by personal knowledge, did he spend some of his time on work for Ms. Schmidt?
I am aware of that, yes.
Okay, so if you look at, actually the second page of that email, I told you it started on another one, do you see Mr. Freeman's name on that list of candidates?
No.
So why would that be, do you think, that neither Mr. Schmidt, Ms. Schmidt or Mr. Freeman is in that list? Especially Mr. Freeman.
Correct. I have no idea why Ms. Lippincott wouldn't have included.
So would you say that that list is inaccurate in that, in not including Mr. Freeman?
Well, I'm not sure, based upon, you know, had Ms. Lippincott already given, and we now know that she had not, but had she already had given additional names to Susan Jones? So his name obviously isn't on here.
So I'd say that would be, for example, that would be speculation on your part that there could have been another note that had Freeman's name in it?
Yeah, so he's not on.
And if there were, couldn't that other note have had Schmidt's name in it?
It could have.
Okay. So, are you aware that Mr. Mancini was being compensated by the Ohio Republican Party?
I am now, yes.
Okay. And would you believe that he should have been in-kinded to Mr. Freeman and Ms. Schmidt for the time that he spent with them?
Certainly, at the very least, Mr. Freeman, I do believe that Representative Schmidt would have relied on someone to tell her, for example, Mr. Mancini, I think, knocked doors a couple of times for Schmidt for Ohio. If they were part of group deployments, the representative wouldn't have had any idea who all of the young people are. So certainly if it would have been reported to her, she would have filed it. But
But that would be speculative on your point, part. If she had done it, what she would have done, you don't
sure,
personally
but it
know.
would be speculative for her to have guessed on a campaign finance report too, right?
So, did you at any point in time when looking at these invoices, being, you know, aware of Mr. Mancini's work and the belief that the high percent was with Freeman and the small percent was with Schmidt, did you ever advise Ms. Schmidt, being her confidant, that she should go try to ascertain for Mr. Mancini what she should have been in kind for him?
So we did, Mr. Mancini and I did have brief conversations about it. He could not remember how many days, 2, 3, 4, 5, whatever the case, nor day parts, you know, or what. So there was no concrete number that she would have been able to place on a campaign finance report.
Do you think it could have been as high as 2, 3 days?
I'm not sure, whatever Mr. Mancini's testified here.
Okay, but you're saying when you talked to him about it, he claimed to you he couldn't figure out within none to 2-3 days, he was unable to
Right.
ascertain.
He was certain that he had knocked on some doors for Representative Schmidt.
Okay, did you ever advise him that he should report something to Mr. Freeman?
So,
Object to questions regarding Mr. Freeman. Again, I think this case involves candidate Schmidt.
Sustained.
I think this case, he brought in this list of
Sustained.
candidates.
Ask
I'm
a question.
asking about the list of candidates and those of being not on the list. Okay, Mr. O'Brien tried to maintain that this was a definitive list of candidates. I'm asking to him, I'm asking questions about the certainty or accuracy of this list of
You
candidates.
started to ask questions about Mr. Freeman and what should have been done as it related to Mr. Freeman and in kind, and that wasn't a part of Mr. O'Brien's testimony or questioning, and so I sustained his motion.
Okay, I think the question I just asked was, did you ever ask Mr. Schmidt that she should ascertain this?
No, your question was concerning whether whether he advised Mr. Mancini to talk to Mr. Freeman, and that wasn't a part of cross-examination.
Okay, did you ever, I think he's already answered that he didn't ask, would you agree he didn't ask Ms. Schmidt to do that? To try to ascertain a number.
What do you mean, ask Ms. Schmidt to do what?
To ascertain a number as to how much should be shown as in kind for R.J. Mancini. Is that your testimony, that you did not at any point in time ask to advise Ms. Schmidt that she should try to ascertain a number to report for R.J. Mancini?
I don't believe so.
Okay, that's the question. I have no further questions.
If I may just ask one or two about these mailers. Is there an upcharge on mailers per piece or item?
It depends. Some mail vendors add a couple of pennies. I, personally speaking, generally added an upfront fee as part of the package, but yes.
Thank you. Quick redirect, so you just said you typically added an upfront fee. So that was separate from the actual cost of the mailings?
It was built into the price of the piece of mail.
But if you had an upfront fee, but the scope, size, and potentially number of mailers was not yet determined, how would you know how to allocate that upfront fee?
Based on, really, based on the size of the project.
I don't,
There are a lot of variables.
I just want to make sure you understand my question. If you said you built in an upfront fee, say you were working with me and I was running for some office, you built in an upfront fee. If I did 2 mailers, even if you thought the scope was 2 mailers, and I did 4,000 versus 5,000 residents, the price for those mailers would be different. So how would you know how to allocate the upfront fee to mailers when the price of the mailers is based on the ultimate distribution list you use for the mailers?
I'm the company, I get to charge what I want. You can choose to buy from me or not.
I wanted just real quick, I think it's the last question, to look at 11G again, oh no, I'm sorry, not 11G, A, or is it A? So it's on the tab that says 723, apparently.
Which one?
It's the one, the invoice, the $39,000 invoice.
Okay.
Okay. So, I think you see a bunch of line items there. The third line item down says SCH additional universes. What do you think that type of language means, or do you know what that means?
That's most likely. I don't want to speak for, this invoice. It's certainly, all these invoices are a mess, but universe would suggest additional names of voters.
So this being a price being paid for, from your experience, for voter list or for curating voter list as to who to send things to.
Could have been.
Okay. But it's not buried in the other line items, it's a separate line item.
Well, we don't, I've actually never seen an invoice like that has additional universes. It could have been sent out later, after the piece was already checked in. I'm just not for sure of the circumstance.
Okay, and then if you go back and look at Exhibit 11, which is another one that Mr. O'Brien directed you to, he said that he made the statement that his exhibits A and B that are there were for media. But do you see on this list some things that, media meaning TV and radio, do you see some things on these lists that are not TV and radio oriented?
Well, stickers, for example, stickers.
Okay.
Let's see.
Well, down at the bottom, there's several.
Okay, yeah, palm cards, postcards,
Mail.
signs, mail, which, just mail, which is bizarre, but
Okay, so then you would agree that there are items on that invoice that are not radio and TV oriented?
correct.
Okay. All right, I have no further questions.
Thank you, Mr. Chairman. Commissioner Member, questions?
I had, well, Mr. Hicks just answered one of mine that I had, and that was about the additional universes. I had a question for him, and he just answered that. But I do have one for Mr. Caraway also. And Mr. Caraway, you didn't get to respond, but you had, during your testimony, Mr. Hicks asked you on Exhibit A on the 39,000, and then on the 20,000. And you had, I believe you said, words to the effect that you know why the bill went from 39 to 20, but I never heard an explanation on that. Could you talk about that, please?
Sure. I believe I testified sometime in 2021. I'm sorry, I can't remember the month exactly, August, September, I'm not, it's all a blur, the time period. Members started to call me. Remember my previous life as a caucus director of House Republicans. Oftentimes I was their first call for political problems or issues. And so calls started to come into me from across the state from members who had gotten collection notices from Mr. Goldstein. We obviously waited some time to see if there were any more, a cure period, let's wait and see if any more come in. Obviously contacted House leadership. House leadership retained one of our attorneys, and I'm sorry, I don't remember which one. We had a few law firms here in town that we worked with, and sought guidance on how to pay these bills. First of all, it's very strange for a political, an invoice for services rendered to be sent basically a year and a half, as I remember, after the actual event had occurred. So there were some questions about campaign finance, amending reports, how do you do this, that, or the other. The other thing that Mr. Lyle was unique was these invoices went out, and in many cases, several cases, I'm not going to say many, the invoice had already been paid by the candidate committee. It was almost like, I obviously don't want to guess, but someone just turned over a bunch of bills and said, well, here, collect on these, but no one had actually input when members had paid those bills in 2018 or 2020. It was a mess. The other thing that occurred is some members destroyed the products that Mr. Longstreth had sold them following his arrest in 2020. So we had yard signs and literature, and members were not comfortable in using those because, they came from his era, so they destroyed them, threw them away, whatever, and reprinted. So we obviously made sure that Goldstein's group could justify every expenditure, everything that they sent a bill for. First we asked the member or the candidate, do you have or do you remember seeing any of these products? Or did you take the service? You took the service, you gotta pay for it. And so they could, in this particular case, they could prove, the bill collector, Mr. Goldstein, could prove, and I asked Representative Schmidt to go through her file at home. She had a couple of mailers, but she had no idea which ones they were at the time. They could prove that the 20,000, I'm sorry, I can't see that. Those, they could absolutely prove without a shadow of a doubt that that service was performed, and Schmidt for Ohio wrote the check. All the campaigns, including Representative Schmidt, were advised not to pay the bill until Mr. Goldstein's group could prove, or the member could, say, yeah, I took that service. I hope that answered your question.
Can I ask one additional redirect?
Based on that question?
Yes.
Go ahead.
Can you look in the book at Exhibit S?
Under what tab?
S?
26, S, the last of my exhibits.
1026?
Yep.
Okay.
So that, way back in there, it's a duplicate of it somewhere else, but on page 16, it has that $39,000 invoice there. It's at page 16 at the bottom.
Okay, 60.
At the other numbers, there's page numbers at the
I
bottom.
see it.
So the 16, 39,000. So it says, you see there's a series of numbers, 001P, 002P, 003P, 4P, 5P, 6P, 7, and letter. Okay? You would agree that that's what's listed on that invoice?
Yes.
Okay? Now flip back to the beginning of the Exhibit S. And I know you said that you couldn't read the little codes down at the bottom,
It's up here.
but I put them,
It's
so
on.
if assuming I didn't make a mistake,
Yeah,
I put those little codes on the pages also.
I see that.
And I just want to flip through them and then have you respond. There's 001P, 002P, 003P, 004P, 005P, 006P, 007P, okay? All the nomenclature of that invoice. Would you say that these existed? That these happened? These mailers
Object to use the word quote happened.
were mailed, were created? Anything? What would you say about these mailers?
Based upon the information that Mr. Goldstein provided Representative Schmidt, they could prove that they mailed, 20,283, not 39,122.
So in the Freeman matter, were you aware of any mail pieces that were not approved by Mr. Freeman directly through text? or
Object
through email?
as to Mr. Freeman,
Sustained, not part of this case.
it's also not follow-up to
To the questions, right, to
To the
the
question.
last question.
So on the letter page, which is page 15, you testified to that before. Did that happen? Do you believe that got distributed to voters?
What page?
Same, we were in the same exhibit. Exhibit S, page
Was it the
15.
Jennifer Black?
Yeah.
Yeah, however, I'm nearly certain that appeared on the campaign finance report as an income, right? No?
It's on the
Oh, I see.
it's on the $39,000 invoice.
Okay, I see.
Now I'm going to object to identifying the invoice with that specific letter. All we have on the invoice is SCH-LTR. We have nothing whatsoever to connect that part of the invoice to the Jennifer Black letter.
Yeah, my apologies.
Okay. All right, I have no further questions.
Thank you. Doesn't appear so.
Are you done with Mr. Caraway?
Yeah.
I do have
Oh,
a
wait,
question.
sorry, Mr. Knight had a question.
I'm trying to ask it in a way that's appropriate for the witness. So, the one thing that seems to be missing from all of this from my perspective, is an engagement letter, right? I mean, typically, as a, at least in my firm's consulting, and never gets unforeseen, or actually any services, lawyers, accountants, or you name it, there is an engagement letter that spells out how you're going to get paid and what services you would provide, such that, right, if you know, if you thought that the mailers were out of ballpark of that, you would call and say, hey, based on our contract, our agreement, this doesn't fit. I guess my question is, I mean, is that how these engagements with candidates and campaigns are typically done? I understand this year's would have been with, you know, GPL, but I would have expected GPL would have had an engagement agreement with all the candidates it worked with. I mean, I guess my question is that the way the industry typically works? Is that how you typically work with your clients? And I mean, that's the missing piece for me. We're talking all these ways you could bill, all of which are plausible, but I'm not seeing an agreement that would have defined that, and that should have been in place, I think.
Mr. Commissioner, I've never personally seen an engagement or a scope of work with a campaign. There oftentimes are budgets at the very beginning. However, budgets ebb and, you know, they fluctuate based on polling or circumstance of the race. You know, you will tell a candidate, you know, hey, we think this is going to cost $150,000, and then you know, the candidate needs to go and work to raise as much money as possible to, you know, to pay those bills. But they do fluctuate. I have ballparked many times, whether it be a township trustee candidate or you know, a candidate for the legislature, to say, hey, I think this is going to cost X amount, but it does fluctuate, and I am not aware. I'm sure it happens, but in my world of, you know, House Republicans, we never had any kind of an engagement letter.
Is it verbal? I mean,
Mostly
how do you
because-
know what you're, is it just kind of understood? You're gonna do mailers and stickers, and, I mean, how do you know what the engagement's going to involve, so you can ballpark it, and do you verbally express the ballpark?
Yeah,
estimate?
well, particularly when House Republicans or Senate Republicans or whomever the hierarchy is, when they're making the decision of who the vendor is. For example, you know, I made decisions along with House, you know, obviously I was an employee, but, you know, the membership of the House, the leadership of the political caucus, upon my recommendation, would use a particular vendor. If that member chose to go and use their own vendor, oftentimes they're out of the family. So we don't take care of that for them. And the reason why we do that, Commissioner, is very simple. In my case, you know, this time last year, thank God it's over, it's been a whole year, I was running almost 70 races simultaneously. If I had to deal with 70 different consultants, it's just impossible for, you know, a small staff of 3 or 4 or 5 people to do that. That's why we look to streamline everything to 1 or 2 or 3 vendors.
That's fair. Thank you.
And then, are you finished with everything with Mr. Carraway, or would you like, I don't want to excuse him if you remind him.
I think he could be excused.
Okay, thank you. You're excused. Thank you. At this time, can we please take a 5-minute break? Do what?
Your boss is calling.
Yeah, he's the boss.
Wait. Do you want her to give 20 minutes?
Yeah, I just,
Okay, all right, so we need a 20-minute break, it's 12:42, so let's be back around 1, a little after. So, okay, it's 1:13, let's come back into session. And Mr. Higgs, and Ms. Bismarck.
Yes,
And at least for the record, I object to me calling her. I know she was instructed when she finished her last testimony, she was down in least.
That
But
was-
since she's here,
That is my fault. I
Yeah.
thought that she was released, so, and I excused her, and I apologize for the confusion on that. I'm so sorry for everybody involved, so.
well, at least it's my view that the chair releases witnesses, not Mr. Hicks. And at least the chair did do it. And so for the record, I'm understanding she's here and she's likely going to go forward and testify.
Okay, thank you for that.
Yep, that's fine. The witness can be sworn, and we'll go forward.
Please raise your right hand. Do you swear affirm to tell the truth when you do the I do. Thank you.
So, Mr. Martin, that book that's right over your shoulder there, this, we're eventually gonna look at that very quickly, and I hope it'll be very quick. When you worked on mailers, or creative work for mailers for candidates, did you get approval from who on mailer, for a given candidate's mailers? How did you get, what was your approval process?
The candidate would approve the mailer.
Okay, were there cases where you did mailers without any candidate approval?
Not that I recall.
Okay. And how would you typically get their approval?
Some sort of communication, email, phone, text.
Okay, so some,
It's case by case basis, everyone's different.
okay. And that book, could you please flip to, there's a little piece of tape sticking out that says 1026 on it. And that whole little section there is an exhibit titled S, it's towards the back, but like maybe 3/4 of the way in the back. Do you find that?
Yes.
Okay. So that's, well, just as a aside, would you recognize these generally as mailers that you were involved with?
Yes.
Okay. And what was your role typically with mailers?
Well, I feel like I've answered this before, but like I, would help write, work with the designer and coordinate between candidate and design work.
Okay. That first one in the lower right-hand corner of it, I don't know if you can read it, it's a lot of how good your eyes are. Do you see the little number down there?
I do.
And can you read it? Can you actually read it?
20OHSCH001P.
Okay, and do you recognize that nomenclature?
Yes.
Okay, and was that the common
Yes.
nomenclature for all mailers? Okay. So are there any of these mailers, there's 1 through 7, that you are not familiar with? That you know,
When
it's
you
not
say
something I was
1 through
involved
7,
with.
what number, what are you referring to, the pages I'm from?
Yeah, well, I apologize, on the things, I put the numbers that are on the bottoms of the mailers, I put up on the right side, so, 001P. And there's 2 pages of that, and then 002P, and then 003P. So, there's page numbers also, but they're kind of blocked by the hole punches. So there's a total of, I think, 7 there, 1P through 7P.
Yep, they look familiar.
Okay.
It's been a while. It was fun.
Okay. And who did you work with on these? Did you work with the Almighty group on the actual then production?
On the design work, yes, they did.
Okay. And then that next, now you can read the page number on it. There's one that says page 15 down at the bottom. Were you familiar with that? It's a letter, it's a brief letter.
This is not, I mean, I have worked on letters, I don't recall the specific one.
Okay. You don't recall the specific one, but with candidates, you did work on some letters, maybe
Yeah,
not.
very, case by case basis, so I don't recall this one, but I worked on letters.
Okay.
Standard.
And then, if you flip back behind that where it says SCH letter on there, which I put that on there, that was not on the original, I just put the label. I have, by the way, I have the
That's kind
originals
of
over here.
misleading.
Well, I have the originals, it's like putting an exhibit tag on something. It's not intended to be misleading, but why don't I give you the original so that you won't feel you were misled anyway. These are originals. There's the original
Okay.
letter. To your knowledge, were those approved and sent out?
I cannot speak to this since I don't recall the letter, but I'm sorry.
No.
Oh, I don't recall, like, I cannot speak to each specific approval and send. I would have to look at, I probably could in March of 2020, but cannot today.
Would you, but what I handed you are originals in your,
Okay. So I'm sure
Would
the
you
person
agree
that
that those are
received it
original?
could speak to, but I did not receive all of these myself, so I cannot say that they were mailed, other than seeing that someone else obviously handed them to you. Although there's no, I assume you blocked out, did you block out the address? There's no address.
I don't know if you can ask me questions, but I'm glad to answer, but.
I'm just
The-
making,
the-
so you could say, like,
Yeah,
I could
those
say, of
were
course,
actually
mail,
provided
but-
to me by various voters in the community.
Object and move to strike.
I'm just responding to her question.
You're not entitled to respond to her question.
Go on.
Okay, and,
Move to strike is comment.
Okay, that's fine. That makes sense. Go ahead.
and my wife erased the signatures because the people were afraid of, being identified, who provided those.
Object and again, move to strike
Concerning?
concerning the statement. There wasn't even a question.
Oh, okay.
I'm just responding to her, so.
Okay.
Well, and I think that the respondent would again reiterate this statement in the record that people who received this were afraid of retaliation is prejudicial, harmful, and should be stricken from this record. And it was not a question, it was a statement.
I'm going to overrule it only because we hear that, this commission hears comments like that on a lot of cases, whether it's a disclaimer case or anything else. I appreciate your concerns, don't get me wrong, but that's not an out of the ordinary statement for anybody that wants to potentially file a complaint or come before the commission.
So on there's page numbers at the bottom of that, and this is actually duplicative of a different exhibit. We can look at the actual original version of this is exhibit A, but it's the invoice that's $39,122. So, looking at those items, I particularly would look at, SCH 007, for example, they're directly to that, and a cost of $5,800. In your experience, is that typical of the kind of cost range of a mailer in a representative race, or at least a mailer in that time frame of the 2020 election?
Prices are a function of the quantity of, the universe mailed and the size of the actual mailer itself. So whether it's an 8.5 by 11 or 5 by 9, or if it folds. So, could this potentially be the cost of a mailer? Yes. Could I denote exactly what type of mailer? I cannot.
Okay, well, but like, for example, that first line, 001P and 002P is 10,000. Would you agree that that's what it says? For two mailers?
I would agree that it says $10,130.
Okay, and you would agree that the mailers that the original mailers that I handed you are labeled as those exact numbers?
Yes.
001P and 002P.
Yes.
Okay, and then if you flip one more page back to what's labeled as page 17, this is actually, I think this one is actually exhibit C or something like that. This is a duplicate of it. Do you see 001P on there, or 001? 001P or 002P?
Are you referring to the invoice number 1127?
Yeah, the one that says the
I do not
balance
see
is
either
20,260.
001P or 002P.
Okay. But you would agree that in the stack that I handed you, the originals and exhibit X, there is a 001P and a 002P, for example.
Oh, I'm sorry. Hold on. You know, because not all of these would be included, so I just noticed that these are different disclaimers. So I
Oh, I might have
actually,
included two by,
So-
hold on,
yeah,
those
well, I'm
two.
just trying to make sure I'm
Yeah, I actually.
understanding, so these are not actually, yeah, that's not, I wouldn't have nothing to do with those.
Okay. So the ones you have should be the ones, I'm sorry, I accidentally handed you out of that envelope. Yeah.
Yeah, here's one, here's 001P,
Okay, that's the one with the coronavirus resource guide on it.
sure.
By the way, did you do those coronavirus type resource guides for multiple candidates? Was that a common format used for candidates?
In March of 2020, during the coronavirus epidemic,
Yeah.
yes, in fact it was.
Okay, okay,
It was very pertinent to one of those.
okay. All right, I don't think I have any other questions.
Mr. O'Brien?
Ms. Fitzmartin, those 7 exhibits in Exhibit S, or there's 7 mailers in Exhibit S that Mr. Hicks had you go through, can you state to the commission that those were mailed for purposes of the primary in 2020?
Yes, yes, sir.
And can you state whether they were mailed or not?
And I can, if they were designed, I at this time do not recall if every single designed mailer was mailed.
So are you in a position here today to say those mailers were mailed to residents in the district that Gene Schmidt was running, yes or no?
I'm certain that some of them were, I cannot speak to every single one.
There are 7 of them that are marked with those numbers Mr. Hicks went through. So is it your testimony, you believe some were mailed, but you can't testify that all were mailed?
I'm seeing mailers right here, so yes, but I don't know exactly, like, every single one was mailed. Because there are different ways of,
Well, sometimes there are things printed but not mailed.
yes.
And there's sometimes the polling that may be done in the district at the time, you decide not to spend the money on mailing something that has been printed.
Yes,
And you don't know whether that happened in this case or not, correct?
I do not recall today, no.
And at least, I have no other questions.
May I see the letter?
So just a quick redirect. The letters in that binder, so just to be clear for the record, Mrs. Martin, did you give me any of these mailers?
I'm sorry?
Did you give me copies of any of these mailers?
Well, I actually don't, do you, which, side of Claremont County? Because you might have received mail that.
No, I'm saying, did you give
Oh,
me any
I
physical,
personally
you know,
handed you,
yours?
no, the first time I handed you anything was right.
Okay, so you would testify that I didn't receive these mailers from you? I didn't receive these physical, I'm talking about these physical finished mailers. I did not receive them from you.
I don't sorry, I don't understand your question.
Okay. Did I receive these physical mailers from you?
I just handed you them,
So the answer is no, I did not.
correct?
Okay, that's all.
Commissioners have questions?
Oh, sorry, yeah, sorry.
I have a couple, Mrs. Martin, just real easy. So during this particular campaign season, how many different campaigns did you work on?
I think we had, like, somewhere, I think I I can go over to like between 10 to 13, I apologize, but
No,
somewhere
no,
in that
that's okay, I
ballpark.
just need to.
Contested primaries, and then I also, helped all the elected all the sitting House of Representatives, so at that point in time, we had 64 seats. Just because someone wasn't in a contested primary doesn't mean that they didn't need help with various things, especially during the pandemic, when everyone had a lot of time sitting at home. So there's a lot of, a lot of extra time.
And then could you guesstimate during that period how many mailers you did for everybody?
In total,
Yeah, I mean, was it 100, was it 200, was it?
probably ballpark, like 100-ish.
Okay, no, no,
Yeah, maybe more.
thank you.
Any questions? May I excuse?
Well, I have a redirect this for clarification. When you said you work with 10 to 13 in response to Commissioner's question, were there, help to clarify, does that mean that there were 10 to 13 for which you were involved with mailers? Or there were 10, what does 10 to 13 mean?
I said contested primaries, it's when there's a primary that there are more than one candidate in said primary race.
So how many races would you ballpark you were involved with creating mailers for? I don't care whether they're contested or in the primary.
Primary? I mean, at least 13, and then some individuals still like to send out mail even if they are not in a contested race for whatever reason to communicate with their constituents. So I mean, say for a handful, just for the, a handful of some of those folks that like to send out mail.
So something in the order of 13,
15 to 20?
15 to 20 for which you get mailers.
Yes.
Okay.
Because again, some like to do it even if they are not in a contested primary race.
Okay, and how many other media, like radio, TV?
I don't know yet. I mean, I don't recall.
A smaller number, greater number, same number? Just a ballpark. I realize you wouldn't remember.
I mean, phones, people like phones, because again, there's time. So,
Let's talk about radio or TV advertising.
I don't recall.
Okay.
Any other questions based on the redirect? Okay. Is she excused?
Yes,
Like, not to re-recall?
yes.
Okay, thank you.
You're
You're
excused.
excused. Thank you. Okay.
Okay, so in light of the new evidence of the actual physical mailers, I'd like to recall Gene Schmidt. And in light of the testimony that mailers were approved by the candidates,
Respondent objects to recalling Ms. Schmidt. She testified, I don't know if it was in May or in July, fully and completely, but called as a witness by Mr. Hicks when she was concluded. I said that I may or may not call her for my case. In fact, I don't think I could cross-examine her because she was his witness and I didn't elicit any information from her after she testified. So at this point, I don't think he can recall her. I don't know how, what his quote, new evidence is.
new evidence is the 7 physical specific mailers
Which
in the
we-
testimony that mailers were approved by the candidate.
Not specifically, not this candidate. And at
Well,
least
I'd like to
I
hear
don't
her
know how-
testify to that.
May I finish? I don't know how many times you would allow Mr. Hicks to recall witnesses in this matter, and I would object. That's not new evidence. It may be new evidence to Mr. Hicks. As I sit here, he could have printed it himself down in Claremont County between the last hearing and now. We have no idea where that item came
We
from.
do from the testimony of Megan
And
Fitzmartin.
Ms. Fitzmartin doesn't know where it came from. She said 2 of them she recognized, the others she didn't, and she can't
That's not
testify
her
that they were
testimony.
mailed. So I guess I would object to recalling Ms. Schmidt, particularly if it's for the purposes of having her testify about these mailers. She's not entitled to do that.
I'm gonna sustain that objection. And, you know, there were general conversation about, you know, the billing and all that as it relates to the materials in question. Just having them here doesn't necessarily change the fact that they were identified as a part of the billing process, et cetera. So you had an opportunity to question her on those previously.
The actual physical mailers is new evidence. You have a right to recall people to comment on testimony and new evidence. So all I'm wanting to do is ask Ms. Schmidt, did you or did you not approve these mailers directly with the testimony of Megan Fitzmartin that she always had candidate approval on any mailers? That's all I want to ask her.
And I would add, if you ask her that, that still does not prove that they were actually mailed. As Ms. Fitzmartin testified to, mailers are often printed and not mailed because.
That's not what she testified to. You're extending what she testified to into broader statements.
The motion, the objection is sustained.
Then I rest my case.
Thank you.
I have prepared at the close of Mr. Hicks's case a motion for a directed verdict based on the evidence that's been presented to the commission.
This motion hasn't been presented in accordance with your rules. You can't just drop a motion during a hearing that's not been presented that I can't make arguments to on real time.
And you can't make a motion for a directed verdict until the evidence is closed on the other side. So I have a copy that I'm going to present to the chair and other members of the commission, and then we can argue whether or not it's wrong.
Well, wait, I just want to make sure that,
Yeah, I mean, you can't, a motion for directed verdict is based on, you know, once the complainant, as the case.
Can I just say a procedural question? Is
Once the
somehow,
complainant rests his case, then a respondent can make a motion for directed verdict that just says the evidence is presented, you know, essentially his motion is the evidence as presented is insufficient to establish his case. And so that's the motion that we have before us. I don't know that I've always seen one in writing. But the commission has regularly dealt with those, and then, you know, Mr. O'Brien would get an opportunity to address his motion, and Mr. Hicks would get an opportunity to respond.
this is a procedural thing. Did she walk off with those mailers?
no, she
No,
gave
they
it
were
back
on,
to
they were right there on your table.
She gave it back to you, and then the others that
They're
were
in-
different disclaimer.
Look inside.
She had them in a book, and this,
No.
but,
She just put it, she just casually tossed them on there.
no, I, you're right, Yeah, I'm sorry, my bad.
No, you're good.
And at least at this point, the respondent would make a motion for a directed verdict based on the evidence that has been presented to you over four, I think, separate hearings, going back to when this complaint was first filed as a preliminary review. Mr. Richter recommended to this commission that charge be dismissed at that time without any evidence before the commission. And the commission members, by a split vote, decided, well, let's let Mr. Hicks go on a fishing expedition for 2 years now in order to collect information and evidence to show that he may be able to make his case. We have a complaint that filed and then an amended complaint. Those exhibits are before you, and they allege, number one, that there were in-kind contributions not reported by the Schmidt committee. The in-kind contributions that weren't reported were alleged in the complaint to be R.J. Mancini, Luke Householder, Tommy Rolfe, and Steve Carraway. There's absolutely zero evidence whatsoever that Ms. Schmidt, who has the duty to report those in-kind contributions, was ever put on notice that she needed to report that. We had Mr. Seekauer from the Ohio Republican Party that paid Mr. R.J. Mancini say and testify before the commission that he did report an in-kind contribution by ORP to the House Republican Campaign Committee. The House Republican Campaign Committee had the obligation to notify Ms. Schmidt of that in-kind contribution, and the evidence is they did not. So how is she supposed to, as Mr. Carraway testified this afternoon, report an in-kind contribution by Mr. by ORP through Mr. Mancini. She can't do it. The other individuals, Mr. Caraway, Mr. Rolfe, and Householder, the only thing we heard about is he parked a car or a truck in some hotel, and Mr. Hicks concluded he was working on campaigns, and because they didn't want the adverse publicity due to his last name, he pulled out of Claremont County right away. And I know that we've had hearings over 4 days, spread over 5 months, but I'm accurately reflecting and remembering that testimony that we heard. In fact, I think Mr. Hicks objected to the characterization that because he was stalking Mr. Householder, he was pulled out of Claremont County. But in any event, in terms of a claim of a failure to report in-kind contribution, there's been a miserable failure to prove that, in fact, Jean Schmidt failed to report, or her committee, that R.J. Mancini in-kind contribution. And I think that the evidence is clear that no one told her that she needed to report that. And Mr. Caraway explained it here again this afternoon, a candidate can't report what they don't know. And so with respect to Mr. Mancini, that was not a fail to report the in-kind contribution violation. The key to these statutes, as the commission is well aware, is knowingly filing a false report. And Ms. Schmidt had no knowledge that Mr. Mancini existed until this complaint was filed by Mr. Hicks. And in fact, Mr. Mancini, when called to testify, said that he at best had been put on a Facebook where he made no posts. He went to a neighborhood meeting where he was asked to take pictures and he couldn't remember if he did. And then number 3, that...
Jack, that's not correct.
It's his argument at this point.
And then 3, that Mr. Mancini went door to door twice, was his testimony under oath. I've attached to this motion and I've provided to the commissioners various items that include a statement by Mr. Mancini during his testimony that he went, I knocked for then candidate Schmidt once or twice. It's page 12, it is noted, page 129 of the transcript, and this is Mr. Hicks's transcript, and on about the 3rd or 4th line, I knocked for then candidate Schmidt once or twice, as Mr.
Caraway is a transcript from the prior case, not this case.
I'd ask the chair to direct Mr. Hicks not to interrupt my argument.
It's his argument. Let him make the argument, and you'll get your opportunity.
Thank you. That's what Mr. Mancini testified under oath. As Mr. Caraway did say here today, how do you measure what that benefit is to the Schmidt campaign, assuming that he did do it, and assuming she knew about it? Knocking on the door twice, if he was paid over a period of 6 weeks by ORP, how do you allocate that to a report that is filed with the Secretary of State by a state rep candidate is under election falsification, a felony, election falsification constraints. So you can't file a report that's false. You can't file a report that you don't know the exact amount that you need to list on the report. And so Peter Schmidt, who's Jean's treasurer, could not file an appropriate report because he first had no knowledge of it. And even if he did, how would he come up with a number? Through that process, the in-kind allegation by Mr. Hicks has no merit. The other claim of an in-kind contribution by Longstreth Constant Content, or JPL, is that this staff, Caraway, Rolfe, Fitzmartin, and Mancini, was provided at no cost. I think it's clear, and you don't have to be anyone other than someone who can add and subtract to look at exhibit number 11, the $164,000 invoice that Jean Schmidt paid $100,000 upon receipt and paid $64,000 on April 2nd with a report. So she acknowledged the invoice, she paid a large part of it, and then she paid the balance before the next report was due. She acknowledged that entire amount, and that amount, when you look at the invoices to Constant Content from Strategic Media, which are exhibits 11, the series in exhibit 11, you don't have to be a mathematician to look at it, although Mr. Hicks would demand that, to see that the $1,500 that Strategic Media charged Constant Content for the photo shoot, that Constant Content turned around and billed $1,650, precisely 10%. You don't have to be a mathematician to look at the radio production and airtime to see that there is a 10% upcharge. And you don't have to be a mathematician to look at the billing on the cable airtime and the TV airtime. There's a 10% markup. And as Mr. Caraway again testified today, you can't keep with 13 candidates or 8 candidates or how many you're working on, a diary that identifies the percentage of your day for each candidate to report to them an in-kind contribution. Gene Schmidt had a campaign consultant, JPL and Constant Content, and they were to do everything that was needed to win that election, whether it was polling, whether it was staff in the field assisting, whether it was creative, whether it was airtime, radio, cable, or regular TV, and they did it. And they charged her a 10% surcharge, which was their overhead and profit. And they don't have to separately report the amount of that as an in-kind contribution. So the staff is not an in-kind contribution, so any claim as to an in-kind contribution has no merit, and Mr. Caraway himself says he does it in his campaign consulting business. The final issue that remains for the commission, and I think is the Goldstein collection of the outstanding debt. We have a $39,000 invoice that allegedly came from February and March of 2020 that is dated, and I think these dates are important, November of 2020, but is sent to and received not by Jeff Longstress or JPL, but by a collection lawyer, Mr. Goldstein, in August of 21. So a year and a half later, the invoice appears out of the air, and you say, gee, this is a convicted felon who pled guilty in federal court who is sending me an invoice for services that a year and a half later, did he really provide him, or is he trying to raise money to pay his defense lawyer? That's a legitimate question, not only Ms. Schmidt, but 10 or 12 other House candidates had. And we heard Mr. Goldstein say and testify that Ms. Schmidt and only one other of those candidates ever contacted him or ever made a payment on the alleged invoice. And Mr. Hicks asked him, well, why do you think she paid this invoice? And his answer was very telling, because she's honest. She looked at it, she asked him to produce the evidence that there were services. Mr. Caraway said that all the other candidates who received a similar letter were told, hey, if you owe it, pay it, ask him to produce it. Mr. Goldstein, his lawyer, couldn't provide anything other than what was paid. And it was a negotiated settlement. It's not a corporate contribution. The services, based on the evidence, 2 years later, and after multiple hearings, and Mr. Hicks scavenged in the neighborhood and producing some mailers without a chain of evidence for them, it still has failed to prove that there was anything other than the $20,000 that Mr. Goldstein and Peter Schmidt negotiated as a resolution. So based on the evidence before the commission, there's not a preponderance of the evidence to go forward, and I'd ask for a directed verdict based on complete failure of proof 2.5 years later, confirming Mr. Richter's belief at the outset that there was not a violation. So thank the commissioners for consideration.
Mr. Rick?
Well, since this was something I had for my closing, but since he has new paperwork, I'll give it to him. This is some notes and a timeline. See what I'll do, I'll start one on this side, over here, just make sure everybody.
Somebody, one of each.
I'm gonna wait till everybody has one anyway. Sorry. Right enough. Getting that, oh, no, this is good, I didn't want to. Order.
That can always go on.
There's a lot of fanciful stuff just said, and a lot of misrepresentation of testimony, including, I think that he said that I said that Ms. Schmidt was honest.
No, I said that Mr. Goldstein, in response to one of your questions, well, why did she pay it? And
I
Mr.
don't remember
Goldstein
that.
said she
Okay.
was honest.
Okay, so here's what I want to hit on here, on this motion, which I haven't even had, which was, how many pages? I haven't even had a chance to digest it at all. So this is not a real hard case. It's hard because it's getting stretched out, not because of me. So this matter should have been settled. There's a timeline document. I handed you a copy, right? In the time, I have another, I think I have an next one. So Commissioner Schmidt wants one. Ron. So in this timeline, I highlighted some yellow things. So when reports were filed, what happened, and I think it's just to be put into context. This should have been resolved almost immediately. Even if you accept this notion that Ms. Schmidt had no knowledge of things going on where the testimony of Ms. Fitzmartin is, for example, that the candidate approved the mailers, then even if that were the case, this should have been cleared up immediately upon pretty much within a week or two of the filing of my complaint. So if you look, I filed my complaint on 6/8/2021. Schmidt received a notice of complaint on 6/16/21 from the commission. The second constant content invoice from Goldstein was on 8/6/21. I amended the complaint a little bit on 8/9 in the hearing, the preliminary review, at which probable cause was found for a full hearing took place. So I just want you to think of that timeline. What should have happened? What do we need to have happen in Ohio campaign finance? Well, when something like this comes up, the candidate just fixes it. Just says, you know what? It's not hard to figure out. You know, Mr. Mancini's, despite its characterization, Mr. Mancini's testimony was first that he spent 1 day a week. Then when I questioned him on that, it became 10%. Then I did the math. Well, that's $700 based on what you were compensated. It wasn't hard to figure out what kind of number should be reported as an in-kind. Similarly, on the Goldstein invoice, constant content's a corporation. I provided evidence, you can dispute it, maybe I made it in my basement, maybe I manufactured something out of thin air, but she didn't recognize that it was fraudulent. I produced the mailers associated with that, and all of the items are accounted for that were on the Goldstein invoice, but she only paid for 4 out of the 8 items. A corporation can't write off. You know, I have an exhibit in here, you can go look at it, the Secretary of State exhibit. The corporation can't write off a debt. That's considered an in-kind contribution from a corporation, which is illegal. An individual or an LLC could, but then that's an in-kind contribution from an individual or LLC that is legal. The reason why a corporation can't do it is because it is illegal for a corporation to make any kind of contribution. That's why the Secretary of State specifically calls out, corporations cannot forgive. They can't write off. So what do I think, you know, in this handout that I provided, I hit the timeline a little bit, but in this handout I provided, I put the letter from your exhibits, Ron, of what was received. What were my allegations? Failure to file a complete and accurate statement. And there's multiple citations there because whoever made the laws in Ohio decided to have the statutes actually have different portions based on whether it was pre-primary, post-primary, pre-election, post-election. So that's why you get a bunch of this, because it's hard to ascertain when should something been reported. Okay? And then corporate contributions. So if I look at this, at just that statement, fair, accurate, complete report, okay? What have I shown? Well, by the way, I put below there where it says probable cause was found, I put the statutory references to each of those code sections on this document, so you can read what do the statutes actually say. Any underlying there is mine, okay, that I added to this. So if I look at what I have proven, not what I'm speculating, is that yes, R.J. Mancini was compensated and did work for Ms. Schmidt. We can argue about whether it was 1 day a week or 10% or whatever, but he did work and he was compensated, and that's supposed to be reported. And there's nothing in the law in Ohio that says, well, if it's under 700 or based on the Mr. Caraway statement, you know, if it had an impact, you need to report it, but if it didn't have an impact, you don't need to report it. None of that's based in law. So I think I've proven that by the testimony of R.J. Mancini, that he did. And I don't care whether it's, you know, I think Mr. Mancini's under a lot of pressure because he has a job in the House where Ms. Schmidt is a representative, you know, to probably minimize the amount of effort he spent, but he can't do it so much that he can't admit, yeah, I did some door knocking. By the way, remember, when he did door knocking, who gave him the direction to do the door knocking? Tommy Rolfe. Tommy Rolfe gave him the direction and the list to go and door knock for. So I think I've proven already that was an in-kind contribution from the ORP, and even if you go with some notion of, oh, it's maybe she didn't know, she had no clue that R.J. Mancini was doing anything, she knew from my complaint. She had the documentation from my complaint, but instead of just fixing her campaign finance report, could you imagine, he likes to bring up that it was a tie vote at first on whether to dismiss or not, you know, whatever the voting was. So it was like a close vote, and then there was another vote, blah, 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 okay? So can you imagine what would have happened in that vote? Had Ms. Schmidt's reaction to my complaint been to fix her reporting and then come in and say, yep, we made a mistake, I fixed the reporting, we're good to go. You guys would have found either no violation or just or good cause or what have you, and it would have been over. And this is what I think scares me, and it should scare you, and it should scare everybody in Ohio, is that we've had this campaign political culture where it's like a game of who can come up with the most ridiculous plausible denial. Maybe I made mailers in my basement. As excuses to get out of any accountability. We need to have a system in Ohio where candidates believe in campaign finance being accurate, that's a value. By the way, you had your earlier discussion about big fines, little fines. You know, the fine schedule's in your own document, so if you don't like the fine schedule, change the document. But my point is, with that is, they either need to have that as a value, or they need to be afraid of getting caught. Look at everything that happened with Larry Householder. This is the Larry Householder candidate. This is all the Larry Householder mechanism. I think I've proven clearly that there were in-kind contributions not reported. And as much as they want to have, well, some plausible denial. By the way, you notice that this 10% argument, why didn't they offer that argument back in 2021? Why did that argument only get developed during the pendency of this case? And I'll remind you of Ms. Schmidt's testimony that when she received the Goldstein invoice, which was after, I just want to make sure I said this right, was after I had filed my complaint, she thought they were so disconnected, this is her own testimony, that my complaint and that invoice were so disconnected relating to Stephen Caraway that she didn't even ask. That was her testimony. It's kind of like what I described. I have some lawyer friends that tell me things like, well, how does the slogan go? Some of you might have heard it, shield and a sword. On the one hand, they were disconnected. On the other hand, that's the explanation. This can't be the way campaign finance works in Ohio. There has to be some accountability. Now, just for sake of this 2-page handout that I sent, provided, on page 2, what is the standard of proof for one of these hearings? What is the standard of proof? So probable cause is the standard to have a hearing, right? That there was probable cause. And I addressed that earlier. The standard for the hearing is, the standard of proof is preponderance of the evidence. Okay? Which is a lower standard than clear and convincing, or a lower standard than a criminal, a criminal conviction would be. It's preponderance of the evidence. What does preponderance of the evidence mean? Something is more likely to have occurred than it did not. I think one of the things that this commission needs to do, and I apologize, I know I'm a pain in the neck, okay, is needs to start having a reputation with the political system that these rope-a-dope things aren't going to be tolerated. That people come in and, I think, I'm not the one making a farce of the OEC. What's made a farce is when candidates come in and they just believe they can get away with stuff on plausible denial. Oh, I didn't know this. When there were activities that they personally participated in. And then they said, well, I couldn't figure it out. Oh, I never could. Did you go ask R.J. Mancini? No. What did you do? I got a lawyer. That was the testimony. Well, why wouldn't you go ask? One key aspect of campaign finance, he mentioned knowingly, and I think these things were knowingly, but there's another key aspect which is good faith. If people start acting without good faith, which I think they do a lot of the times in Ohio, where do we get? What's the whole point of campaign finance? What's the whole point of this body? What's the point of any of these laws if we have a political system that tolerates on this? For example, this case, by the way, this is a Larry Householder deal. This isn't just Joe Blow, county commissioner, that kind of thing. This is where lots and lots of money was being thrown around in this. So when it comes to the bottom of that, however the reports, he made the statement that I guess what he's saying is this should be dismissed now because I haven't proven anything. We just spent 4 days, hanging out, listening to jibber jabber. I think I proved a lot. I think I've established by the testimony of the witnesses that R.J. Mancini did provide compensated services for Gene Schmidt, and they were never reported anywhere. I think I showed, by a preponderance of the evidence at least, that these field services things were not rebuilt anywhere. It's very convenient. Nobody has any actual contracts, evidence, or documents that talk about any of the things that are being said as to how this was probably done. I think by a preponderance, is it more likely or not that these things were not being rebuilt to candidates or shown as in kind? And then the killer on my last one, which was corporate contributions, I basically got them to admit they accepted an improper corporate contribution. How? When they negotiated that invoice into their own testimony, when they forgave part of it, when Constant Content forgave part of it, it's a corporation. I've shown copies of the individual mailers that went out. Other than me making them up, fabricating them in my basement, how would I have otherwise done this? And the point being that there were, all 8 things are accounted for. That Goldstein invoice, all 8 things were accounted for. The invoice, a lot of times they want to not look at actual records, like there's no agreement, there's no contract, there's no nothing. You're just supposed to believe stuff. The actual record shows that they only paid for 4 of them. $20,000 something. So I think I've proven that they accepted a corporate contribution when they, after consulting with the Secretary of State, apparently got a corporation to forgive $20,000 in debt. Can't do that in Ohio. And the next thing you know, if there's never any accountability for this stuff, hey, why doesn't Procter & Gamble just spend $2 million electing a candidate they like and then just never tell them? It's all okay then. So I think these cases, and I apologize, and I'm very passionate about this, and I think campaign finance, clean campaign finance is something we need to all strive for in Ohio. is that there needs to be a point where candidates don't go through these rope-a-dopes that take my time, take your time, take everybody's time. But as it goes to the actual case, I don't see how you dismiss a case where I've absolutely proven that R.J. Mancini did compensated work for Gene Schmidt. I don't see how you dismiss a case where by their own testimony, they had $20,000 worth of debt forgiven by a corporation in violation of Ohio law. Okay? I don't know how you go on the presumption that this invented 10% scenario that never came up in 2 years. He likes to say it's been going on for years. It's only been in the last, 2 meetings that this 10%, it was the last meeting where this 10% thing came up, the Ron O'Brien 10%. Okay? That just came up in the last meeting. That was the first time that was presented. Why wouldn't that have been presented 2 years ago? So that's my response. Again, I don't think this is due process. I don't have the ability to absorb this. You know, there's this, it gets thrown on my desk, a big thing. I don't know how regular court works. You know, but I think that probably, if I was a lawyer, counsel for the other side would have a chance to absorb what was actually in the document. Okay? So, but suffice it to say, I think that this motion to dismiss, directed verdict, would be to accept it would be an affront. When I have shown very clearly by a preponderance of the evidence, more likely to happen than not, that R.J. Mancini did compensated work for Gene Schmidt that was never reported, that they accepted an almost $20,000 corporate contribution when Clemson Content forgave a bunch of mailers that did take place, and that you have to believe in fantasy to think that the Steve Carraway story that never existed until the last meeting is a valid story as to how they got rebuilt, which, by the way, they can provide no evidence for other than Mr. O'Brien making exhibits. So thank you for the chance to comment.
Thank you. What is sorry about this?
By the way, could somebody explain what's the process on one of these motions? Since I don't know, like, he's just getting up and starting to talk now.
Yeah, it's called rebuttal one, Mr.
Well, I didn't ask you guys, somebody explain the process.
At the you concluded your case. At
Yeah.
that point, then a respondent has an ability to move for a directed verdict, essentially asking the commission.
No, I was meaning more specifically, tell him just standing up and starting to
I
talk.
was just going through the whole process.
Okay, thank you.
You know, he moves for a directed verdict. If the commission at the end, if the commission decides to accept the motion and act on it, then it essentially finds that there's no violation of the case is over. But anyway, he gets up and makes his presentation as he did.
Okay.
You get up and make your presentation as you did, then he's given a brief opportunity to respond briefly. Then the commission will decide whether it wants to accept his motion for the directed verdict or not. If they do, then the matter's done. If they don't, then it goes forward, and he has an ability to then provide whatever evidence as a part of this case that he wishes to provide. That's the process.
Okay,
And
thank
I
you.
appreciate, normally, I don't know that, I mean, we have in the past, when cases have, it's been a while, when the cases have reached this point, we've had directed verdicts before. I don't know that we've ever gotten an actual written directed verdict motion. Generally, it's the respondent's counsel stands up, I'm moving for a directed verdict, here's my arguments, the other side argues.
Okay.
And so that's where we are. He gets an opportunity to briefly rebut, and then that's the closed argument, and then it goes to the commission members.
Thank you.
And at least in terms of response to what Mr. Hicks says, there's not one bit of evidence that that debt was forgiven. Mr. Hicks specifically asked Mr. Goldstein if Constant Content, quote, wrote off that balance of the debt, and Mr. Goldstein said, I don't know what they did. I'm their lawyer for collection purposes. I'm not their internal corporate lawyer, and I have no idea. There's no evidence. In fact, the evidence is via the exchange of the emails, the letter from Mr. Goldstein to begin with, is that there was a negotiated settlement based on what Mr. Goldstein and the vendor, Mr. Longstrike, could show they provided. And it was the $20,260 that they could prove, as Mr. Carraway said, their people were told, if they can prove the services were provided, pay for them. And Gene Schmidt, and there's an email from Peter Schmidt to Brian Katz at the Secretary of State's office, says, look, we just want to do what is required by law and what's fair, right, and just. And Mr. Goldstein himself said she paid what we could show her she owed. And it hasn't changed since then. Mr. Hicks has produced some flyers that are related to the Schmidt campaign, but there's no evidence that 1, 2, 50, or 5,000 of those were printed, or 1, 2, or 50, or 5,000 were ever mailed. And he, since it's his witness, he can bring in whoever it is in Claremont County that says they received those mailers in their mailbox. He could have brought them up here, and they could have taken the stand, and they could have taken that chair, and they could have, like Ms. Fitzmartin, answered questions. But he chose, intentionally, I might add, not to present that evidence to this commission. And the commission's entitled, as Mr. Richter will tell you, to take an adverse inference from the fact of him failing to produce that information. All we have is some flyers that he says he got from somebody who doesn't want to be identified, and Ms. Fitzmartin saying, yeah, I can't tell you if these were sent out or how many were sent out. And so there was a negotiated settlement. It happens every day, and that negotiated settlement was not a forgiveness. John Glenn went to his grave owing tens of thousands of dollars on his presidential campaign. That doesn't mean that he took an unlawful corporate contribution. This commission would think that we do indeed owe that other $19,000. I think that Ms. Schmidt would the very next day file an amended report and say, we have a outstanding debt of $19,000. But the thing is, he has not proven. He has chosen to file a complaint and an amended complaint alleging criminal conduct, I might add, that this commission hears first and can have an option, as you know, of 1 or 3 alternatives, one of which is to send to the prosecutor. So the question is he presented information sufficient that would cause you, as one of the options, to feel he has proven by preponderance a corporate contribution, an in-kind contribution, or a forgiveness of a debt. And that clearly is not in the evidence. It's his case, his complaint, his charge, and he has failed to prove it. And for all of those reasons, R.J. Mancini, if he indeed did work on the campaign, and if indeed his time is $700, once again, that's something that Ms. Schmidt, I'm quite sure, would be willing to amend the report and to pay whoever is due to be paid. The ORP, HRCC was in-kinded. We saw the email about who does ORP need to be in-kinded on. Ms. Schmidt wasn't under this. Ms. Schmidt has been very diligent trying to file the reports that she needed to file. And the allegations are that she and her campaign knowingly failed to include this information in reports that were filed. And clearly, if Mr. Hicks wants to say today that knowingly she is aware of certain things, that's fine. But back when the report was filed, she didn't knowingly omit Mr. Mancini. She didn't knowingly fail to include an invoice that she didn't receive until August of 21. So based on the information, the respondent would ask for the directed verdict. Thank you, Madam Chairman.
Commission member, it's now in the hands of the commission as to whether, and again, this is determining whether the commission wishes to accept the directed verdict, essentially declare the matter resolved, or overrule that motion, and then Mr. O'Brien would get an opportunity to present any evidence if he so chooses.
Madam Chair, I don't think we ever got a chance to see this exhibit. Is it possible to see those?
Oh, the original.
Well, I object to the admission of
Wait,
those
stop, wait.
documents. Yeah.
I'm sorry.
Excuse us, hold on, one minute. Wait, stop.
Or are they here?
Okay, we'll have to address that.
And this must be really important.
Yeah, I'll stick it with files. This is for the
Okay.
case.
Okay, thank you so much. Thanks for running those years. Yes, I appreciate it. Sorry.
I think respectfully,
Hold on, not your time to talk.
This is our time for discussion.
well, I was just going to note, those documents are not in evidence. He
Oh,
did not
gotcha,
offer them,
yes.
they were not admitted, and the fact finder should not see or hear them, so for what
Okay,
that's worth.
thank you. Okay, I didn't know what we were talking about. Okay, thank you, Mr. Wright.
No, we don't.
Commissioner Hagan, since those were never admitted into evidence as exhibits,
How were they not admitted into evidence as exhibits when they were then not?
we should have all received, she should have had to.
You got them, I sent them to you.
Oh, yes, you're right.
You have
No,
notes
no,
of them.
no, you know what you have in your hand.
These are only to authenticate what I provided you in copy.
And what you provided to them in copies does not admit them into evidence. They have to be admitted into evidence. You
That's at
cannot-
the end,
Oh.
when we go
You
through
rested.
admissions
Okay,
of
time
evidence.
out,
He
time out,
rested.
time out. What you have in here, okay, so those are whited out, right? These are blacked out on here. So what you did was you made a copy of that, scanned it in presumably, and then blacked out the address. So that is exactly what we have on, that was given to us, what? a few days yesterday or
I think I
yesterday.
circulated them along to everybody.
We do
yesterday
have
in
that.
the email.
But instead of, I see why you want to see that. But he's saying, Mr. Hicks is saying is that what we have in this email marked Exhibit S, where it's blacked out, on there it's whited out, correct? So
These
we,
are the originals of that.
those are the
Yeah.
originals. So can we look at those since we have copies?
I appreciate Mr. O'Brien.
Madam Chairman, that is not evidence even on your computer, and you cannot consider it. I raised this at
That hires evidence.
at every other trial, administrative hearing, in this state and in this building. Evidence is marked, you move to admit, it's admitted into evidence, it's therefore in the record. If there's an appeal to common pleas court, Mr. Richter sends that to the court. Merely emailing to you a document does not render it admitted in evidence. And he rested his case.
But we really haven't, and I appreciate what you're saying, we
Well,
probably should
that's
have
the
asked
law.
him to admit his case, his evidence, but technically under that argument that we haven't admitted any of the evidence, and I don't think that does a service to the commission at this point.
Well, there was a document that was submitted to me and marked in red what was admitted and things that were
That's what I was gonna propose.
not
at the end,
admitted
admitted
were
and not.
Xed out.
Right, but I don't think we ever acted on that.
Well, I don't think he did either, but he rested his case.
But
And
we already have it as an exhibit, right?
But we already have it here, and you'd be welcome to make your argument if we don't, if this thing moves forward in some manner or form, but I think we should take them, to me, in an effort to try and be equitable here, we should take them in, accept them as exhibits, since we essentially have had them available to us. I appreciate the difference, but I'm gonna say we go ahead and accept them as exhibits, let them look at it, and if it comes down to it later on, you can certainly make that argument.
I guess respectfully, I don't think it's an argument, it's the law. He did not admit it and move to admit them into evidence. They're not in evidence. There's no chain of custody for these documents. They appeared here in court by Mr.
And that's all of it.
And you need a chain of custody for evidence of any kind, sort, or nature. So I guess I will, note my objection for the record and
Thank you, your objection is noted. But I think for the efficiency of the commission to move forward, I think it's appropriate to let them be reviewed and go forward. Your objection is noted. And we've over the years, we've entered exhibits over objections as well, so.
Madam Chair, may I provide context on why I'm even interested?
Yes.
I'm just curious to how we know that these landed in mailboxes or not. Because that's, whether it was printed and delivered and whether it was drafted and printed versus hit the actual recipient or not. think bears some weight, so there's no way for us to really know that specifically.
Am I supposed to hand these to anybody?
I don't object if you hand them to the chair for her to review and make a decision on whether to pass it around. I think that's precisely my point, that they shouldn't be admitted because there's no evidence that they would have mailbox.
There's no evidence of any of these invoices. They're not original copies. They're not, so every piece of evidence we have then is not evidence.
Sure.
So I have a question, Mr. Hicks. Where's the envelope for the letter?
The person that gave it to me did not have the, did not retain the envelope. By the way, the letter, I would testify as to I've received most of those in the letter I received, but I didn't keep a copy of it, because I live in the district.
Okay, but those aren't yours.
No, those are from people that brought them to me. Who have received them and kept the copies.
He said to describe his comments in response to
I'm just responding to
her
the question.
question.
No, I just asked about the envelope. I just asked about the
And I
envelope.
think that's the problem with him producing them and saying, here they are. I can't ask the recipient, did you get it when you got it? Why did he keep it for 2.5 years? As,
So I mean.
That's from my wife erased them off of there, so it changed the texture a little bit.
How do you erase them off of there?
My wife's a professional artist. They have erasers that take off the ink.
Oh, take off the ink?
That erase the ink for the addresses, because as I said, the people that gave them to me were concerned.
All right. So you're saying these came through a mailbox?
Yeah, this came through two
Okay.
individuals.
That's impressive. All right.
You saw the letter as well.
What's impressive is that people say this kind of stuff. I know I toss it.
Yeah. Do what?
Advanced smart recycle box systems like want to get it there.
It may be appropriate to have a short recess and the commissioners discuss among themselves the outstanding issues.
Are we ready to do that?
No.
I didn't
Oh.
think so.
Well, that would make sense.
Do what?
I say that would make sense, but if you're not permitted to do it.
No.
Mr. Director, I should know this, but as far as construing the evidence, that would be appropriate in the motion to dismiss, but there's no construing the evidence against the defendant in a directed verdict. Is that correct?
I think you do, because it's a matter of assessing whether there has been sufficient evidence provided by the
But
complaint.
it's not construing the evidence against one party or the other.
Oh, okay, yeah, you're assessing the evidence,
You're assessing.
correct. That's all you're doing is assessing the evidence. I misunderstood, I apologize.
Could you explain that to me?
You're not looking at it, in a motion to dismiss, you essentially favor the presentation of evidence from the, in this case, from the complainant, and you look at it in favor of him and more or less not taking into consideration the respondent's position on it. But if you're acting on the directed verdict, and so, you kind of say, okay, that's that. In a directed verdict, you assess the totality of the evidence presented, taking into consideration what it is that the respondent may have also, provided during cross, essentially, because he hasn't provided any other evidence at this point.
Thank you.
So isn't, I'm not a lawyer, I'm just looking on my phone, but isn't the standard of review in a directed verdict that the evidence most favorable to the plaintiff must be accepted as true? So a directed verdict would say that if all the evidence I provided was true, then there still would not have been a basis to find guilt or, so that I think the standard, by me just looking it up here, but there's a couple lawyers here, in a directed verdict would be that if giving me the favorability that the evidence was true, that still would not have manifest a violation.
Okay, that's fair.
If the evidence is believed.
If the assumption is that it's true, that's what it said, I just read off. The assumption being that if the plaintiff's evidence were true, it would not provide a basis to find a guilty verdict or a violation.
Okay, it's before the commission now.
In hopes of, moving this forward and hopefully having this case end at some point prior to 2024. My view, certainly of this motion, would be to deny it. I think that it's just based on R.J. Mancini's testimony. I mean, he said that he performed work for the Schmidt campaign. He did door knocking and he was compensated for it by the Republican Party. I do not believe that Mrs. Schmidt was aware of it, but nonetheless, my understanding would be that whether we find a violation or not, there needs to be an amendment where that amount is determined and an amendment to the report filed. So I don't see how we could, dismiss the complaint and do a directed verdict based on that alone. Also, based on the testimony of Mr. Carraway, actually today was opposite to, at least, and I will acknowledge it's been a month and a half and I may not be remembering his testimony perfectly, but I remember Mr. Goldstein testifying that he was unable to produce any proof whatsoever on any of these, and that when we heard it today, and Representative Schmidt testified that there wasn't knowledge of this, wanted it to go away, and there was a settlement negotiated, right? That's how I remember it, and I could be remembering it wrong. You know, that's one of the challenges with having this extended over, right, several weeks. So if that is the case, and perhaps it's not, that's how I remember it, then you would have this remaining balance that again, now would be contributed, I guess, by doing the negotiated settlement. You're kind of acknowledging that something needs to be paid. So, I mean, at least based on what I know, my inclination is to, almost violations for good cause, that with a request to amend the reports as would be required legally to create those. I certainly don't believe there was anything done purposely or to try to skirt law. I mean, I think this was a really weird mistake, but from what I understand, I do think there are a couple of amendments that would be required. So again, would love to hear others' perspective. I acknowledge I may not be remembering every testimony perfectly, and apologies if I'm remembering something incorrectly. But certainly at this point, I don't see the support for directed verdict and dismissal.
I'll take a swing since we're in order. You're supposed to, or we are supposed to bring to bear what we've experienced in life and professions and things like that. So I was a candidate. I know this world well. Sagan, I'm sure, remembers this world well. What the candidate needs to be told, we have the same contributions. So I'm not sure that R.J. Mancini's saying that he did door knocking. And I think her testimony was she had no idea if anybody else was doing anything else. So I don't see that as a problem now. And it's not R.J. Mancini's responsibility, it's the Ohio Republican Party or whoever he's working for to send out that in kind, not to have the candidate guess at that. Because we have door knockings all the time with people who show up on volunteer time and things like that. They're working for the caucus and they help us. The disputed settlement thing, I look at that and it is interesting, but it's not as if constant content forgave anything. And if they did, that would be constant content's problem, not the recipient of that. But it's a disputed amount. It was a contested amount. It was an amount that the candidate said, we don't know this, show this that we did, and they couldn't apparently. And again, there's been very little testimony about the details in there, but it's not a forgiven amount in my view. There are other things in here that I look at, and it's it's like that. Those sort of things happen, but the candidate is responsible for what the candidate knows. There's one other point I want to make. However, as my question to Director Richter was, how do we do this? And it is construing the evidence most strongly in favor of the complainant. And if that is true, then we have to take out for the moment the balancing of the evidence. We have to suggest that those arguments and that evidence is construed most strongly in the complainant's favor. So for that reason, I would be in favor of denying the directed verdict at this point in time.
Yeah, I'll just weigh in, and I think for me, and I appreciate both those comments, because I was very comfortable about the directed verdict. But I think the one thing that stuck out to me was kind of the Mancini piece. I don't know if I fully understand on the information we got, the write-off of the excess content. What's the name of the place? Constant content. But I think the Mancini piece as well, And I guess as I view it, I think whether you're a candidate or not, if you get the information, really at any point in time, you have that ability to amend. So I would be, at this point, really weighing in on kind of the motion, or the motion to deny this motion.
Any comments, Mr.
Well,
Lyon?
I have some questions, I don't know, this is the appropriate time based on this motion, so, I guess for Mr. Richter, so, kind of going with what Peter said, but how do you know when a debt is a debt, Bill?
I don't know that there's anything that specifically identifies it, but certainly you would have to be, I think as a person that is involved in the activity, you'd have to know in some manner or form that you were obligated to make that payment. You know, kind of like a mortgage on your house.
But I mean, so you have a situation, could be any of us, so we contract for something. And now we have the contractor says you owe X, say, in this amount, 39,000, and we say, well, we don't owe that, we owe 20,000, some change, because you didn't provide the service.
Right.
So just because a contractor tells you, and obviously there's no, what was that you called it before? You were talking to Mr. Carroll.
An engagement agreement.
Yeah, there's no engagement agreement. So how do you know? I mean, I've run campaigns too, and, you know, things can fluctuate, or they don't do what they say they're gonna do. So do I not have a responsibility to pay them? I don't think I do. I don't think, I guess when you look at it overall, you know, I still have a responsibility to my campaign and my fund, and the people that donated to that. So I have to do my due diligence and be prudent that I'm paying the proper bills, correct? That's how I look at it. So that's just a question about a debt is a debt. That's what, because there is a question when you look at the corporation, and I know what Mr. Hicks presented, and I would, looking just at it, I would agree with him. However, after looking at the evidence, I don't necessarily agree with that. I know I'm supposed to be talking about the directed verdict, but so I would not be in favor of a directed verdict at this point. I'd rather have us deliberate because there's other issues out there, like, and I think Mr. O'Brien said that if Ms. Schmidt knew, this goes back to the knowingly standard, about R.J. Mancini, that she then would correct that. So now the question I have to you, so there's a complaint filed. We have the respondent. Did they, during this long hearing that we've had over the years, and nobody's fault, but it's extended, is there a responsibility of a respondent or a candidate if they find out information during the hearing before it's concluded? Does the law say that they now have to amend the report? That's his argument, that's what I'm asking.
I don't think the law really speaks to it, and there's certainly, it's one thing to come into certain knowledge, but is that knowledge an actual identification of an event that needs to be reflected in a campaign finance report?
Before a hearing.
Before the hearing is concluded, that makes a final determination on that factual issue, or presumed factual issue.
I mean, especially given that it has been a while since this all took place. It was during COVID. I think everybody was probably, my mind is still foggy from COVID. In Mr. Hicks' document, it says first claimed 1 of 7 days was spent on Schmidt and Freeman, and then revised it to 10%. Does he really know? You know what I mean, or is it just a kid who's scared, who's sitting up here? I'm not excusing, or he said what he said. But I'm just saying, where is the accuracy? Where do we actually, how does he know what to report to whomever so that, you know, Representative Schmidt can actually correctly amend a report? It seems like there's, to your point, there's a lot of time that's gone by on this, so it makes it difficult for, you know, for everything to get nailed down so that everybody's compliant in a way that I know, I mean, I feel that you would want to be. I feel that you try to, you know, to put the things in there that you knew of, and if you didn't, then whatever, but again, that's just, you know, just how do you know what to say? How do you know what to put down? How do you know what's accurate, what's, you know, inaccurate after 2.5 years? It makes it very blurry.
And then we also have an affidavit from Rob Secar, Executive Director of Ohio Republican Party, whose affidavit, supposed to be truthful, I'm assuming it is, says that R.J. Mancini, any other person, did not specifically assign them to volunteer to work with Gene Schmidt.
But Commissioner Lau, if you recall, they sent, the ORP sent resources to JPL to work under JPL's direction. It was Tommy Rolfe and JPL who sent Mancini to Freeman, and so JPL got resources ORP was paying for, so he was directed by Tommy Rolfe to do this work. The ORP, as I understand it, should have informed the campaign of that in kind, and that did not happen.
Fair enough.
So Rob's reporter's affidavit is accurate. They didn't direct him.
I got you.
They directed him to work for JPL, who directed him. So it's not, it's kind of misleading, to be blunt.
Well, it's only like pure facts where,
Well, no, but it's truthful.
yeah,
It's truthful.
it's truthful,
It's
but
accurate, truthful.
but there's overlap.
So anyway, I have a bunch of questions.
Oh, I'm
but
sorry.
No, I already asked them.
Oh, okay. I thought I interrupted, I apologize.
No, you didn't interrupt me.
I'm sorry.
But I would be of the mind to object to the directed verdict at this time.
Are you making a motion?
I don't know if I can speak on something and make a motion.
Everybody else has spoken, as
So we're
Ms.
going to
Hagan,
deny
so.
the motion.
But I mean, you really shouldn't speak on a motion and then make your.
So so what we're saying is, someone's making a motion to deny the motion for a directed verdict and to dismiss the complaint.
I will move to deny respondent's motion for a directed verdict and/or to dismiss the complaint.
I'll second.
Okay. We have a motion on the floor that's been duly seconded. Mr. Richter, will you do a roll call vote, please?
Mr. Lyle,
And I want to make sure.
motion
I'm
is to
clear.
deny the motion for directed verdict. And or to dismiss.
Well, the motion isn't and to dismiss.
To deny the it's to deny the motion for directed verdict and or the motion to dismiss.
That's how it's stated
It's a
on this.
procedural
Okay.
term.
Right.
It means nothing about what happens at the end of the case. Sorry.
I would say aye.
Ms. Hagan,
Aye.
Mr. Stoutberg,
Yes.
Mr. Hawken,
Yes.
Mr. Knight,
Aye.
Chair Kaufman.
Aye.
Okay, the motion for directed verdict and the motion to dismiss is denied. Mr. O'Brien, you can put your case on.
Okay, thank you.
The procedural question, I hope this will be over today, but is there a timetable on it? I have a meeting in Cincinnati at 7, I'd like to get through that by 7, so.
We all have things that we have to
Okay.
get done with school personnel. I feel like we do that.
I always have to say it's really important.
Hey, they
PTO.
are.
True.
Yeah, parent-teacher program.
Okay, so,
I still have other important meetings, guys.
that's important. Okay.
Thank you. If you could swear the witness, this is Curtis Mayhew.
Raise your right hand. Do you swear upon the top of the truth, the whole truth, and nothing but the truth?
Sir, will you state your full name for the record?
Kurt Mayhew.
And Mr. Mayhew, during your government employment, were you ever employed by the Secretary of State's office?
I was.
And when did you start there?
January 7th, 1990.
And who was the Secretary of State?
Sherry Brown.
And you worked for Sherrod Brown through the balance of his term?
Did.
And who was the next Secretary of State you worked for?
Bob Taft.
Bob Taft. Did you work through his 8 years as Secretary of State?
Did.
And did you stay under the succeeding Secretary of State?
I did.
And that was?
Ken Blackwell.
In Blackwell. And after his term, the following Secretary of State, who was that?
I was retained by Jennifer Bruder during her 4-year term.
And so far, these are both Republican and Democrat elected Secretary of State,
Yes.
correct?
Yes.
And after Jennifer Brunner, did you stay in the employ of John Houston, who became Secretary of State?
I did. I served through his first of 2 terms.
And when did you leave the Secretary of State's office?
In mid-2015.
And during your time with the Secretary of State's office, did you hold a position at all with respect to campaign finance?
I did.
Can you tell the Elections Commission what that was?
When Secretary Taft was elected, he put a focus on campaign finance and established a small unit that eventually grew into a larger unit. I was in that unit from the beginning in 1992. And I led that unit from 1998 until I left in 2015.
And we've heard the name Brian Katz throughout these proceedings, who's the Director of Campaign Finance at the Secretary of State's office currently. Is that the position that you were in during
Yes.
the time you described?
Yeah, yes.
Okay. And I take it by that background in employment, you're familiar with campaign finance requirements under Ohio law.
I am.
And in fact, you're familiar with the operations of this commission as well, correct?
I am.
And in terms of reporting in-kind contributions, must a candidate know about an in-kind contribution before they have an obligation to report?
Certainly.
And how typically would a campaign or a candidate know about a in-kind contribution that anyone may make?
I'm not entirely sure. I mean, they can only report what they know. In fact, I know that when we would do training seminars, we would often get questions about, hey, look, I understand a friend of mine mailed out some letters or some things like that. I'm hearing that happened, but how do I report that? My advice was you don't have any duty to report something that you didn't coordinate with the other party.
And can you report something in an unknown amount if someone has provided in-kind contributions to your campaign and you learn about them? If you're unaware of what amount to report, what should you do?
I don't know that there's anything to report until you have some sort of dollar figure. And if it's not something that was done with your consent or coordination, I'm not sure you have an obligation to disclose it.
And Mr. Stephen Caraway, who testified previously, talked about reporting in-kind contributions that are quote-unquote measurable. Can you tell us what that concept is?
Well, you know, with the campaign finance law, it requires you to be specific about the dollar amounts. for contributions that are received, whether they're cash or kind. There are a lot in the campaign, there are a lot of undetermined valuations of help that you can get. You have someone who has a convertible and you want to use it in a parade. You just happen to have a friend with a convertible willing to set you up in a parade. I don't know that you can automatically conclude that that's a new kind of contribution.
And did I ask you to look at a series of documents in this case in connection with a man named R.J. Mancini?
Yes.
And R.J. Mancini was on the payroll of the Ohio Republican Party. Was that pay stubs that you reviewed?
I believe that's the case, yes.
And Rob Seklar, also from the Ohio Republican Party at the time, testified that he did put him on the payroll and in-kinded his payroll to the House Republican Campaign Committee. If you assume that to be the case in the evidence, whose obligation would it be to notify the candidate?
The candidate?
Whose obligation would it be to notify the candidate that there was an in-kind contribution to the campaign?
If there's an identifiable amount, I would say it would be the House caucus.
And if you assume that the House caucus did not or failed to report to the candidate the in-kind contribution that they received from ORP to benefit the candidate, would the candidate have a duty to report something they had not been notified about?
I can't see how they would, no.
And would, during your time at the Secretary of State's office, would you file a complaint with this commission under those kinds of circumstances?
No, not at all.
And in terms of campaign consulting, if someone hires a campaign consulting firm and there are multiple people employed by that firm, typically, or campaign finance law require them to allocate each individual employee and what amount of time they spend and what amount that was paid when making reports to that candidate.
No.
And if we look at campaign consultants, are you generally familiar with their billing procedures in terms of covering overhead?
No, I couldn't say that.
So you're not involved in that at all?
No.
If a corporation which did provide services to a candidate invoices that candidate and the candidate questions whether all the services were provided, what should they do in that circumstance?
Well, just like any other transaction, they can always dispute the charges or ask for some sort of itemization or explanation of the bill. Happen pretty frequently, frankly.
And what duty is it on the candidate then to report when there's a questionable or contested invoice that's received from a vendor?
Typically, I think the dispute would get wrapped up within the time frame of a reporting period. So I don't know that I would see a lot of back and forth just within one report. But if the dispute lasted for a time, then they could report it as an outstanding debt. Or what I would typically advise a campaign committee to do would be to enter it as a debt, but sort of disclaim it as this is in dispute, but I'm reporting it out of good faith just to ensure that it's part of the record.
And did you look at the Dunning letter that Attorney Dave Goldstein sent to the Schmidt campaign in this case?
Yes.
And totaled around $39,000.
Right. The
And
initial. invoice.
The initial invoice, and then there were communications back and forth that you see via email and handwritten notes with Mr. Goldstein and the Schmidt committee. Did you
Yes.
see those communications? And did you see the report that then was filed for $20,360 at the Secretary of State's office, first as a debt and then as a payment of an outstanding debt?
Yes.
And from looking at those documents, do you have an opinion whether or not the Schmidt campaign properly handled that billing, if we want to call it that, from Attorney Goldstein?
I do.
And what would that opinion be then?
Well, my opinion is that it was something that was resolved in the normal course of a campaign. I mean, I think it was disclosed properly from the beginning and then completed properly.
Would you consider a negotiated settlement of a disputed bill from a vendor that results in a settlement? Would you consider that as a corporate contribution?
Nope.
And tell the commission why.
Well, in this particular set of facts that I reviewed, the invoice originally submitted, or the invoices originally paid by the campaign committee for mailers 1 through 7, I think that they were numbered, among other things, that when Mr. Goldstein followed up after the fact to collect the debt, he included a lot of things that the committee had already paid for. And so then the follow-up after that didn't have any detail. It got shorter in terms of what it contained for the 20,000. But at each iteration, at least from my calculations, it looked like frankly, the Schmidt campaign overpaid for the services that Constant Content provided. Ultimately, you know, in the amount of about $1,000, I think if my math was correct.
And did you look at the original invoice from Constant Content that totaled $164,334?
I do remember seeing that.
Did you compare that with invoices from Strategic Media and make any observations about markups?
I saw the document from Strategic, but I didn't make any conclusion from looking at it. I assumed that there was some professional interaction between Constant Content and Strategic.
Okay, if you assume that there was a subcontractor kind of relationship between Strategic Media and Constant Content, and Strategic Media invoiced Constant Content, who paid an invoice, and then Constant Content then invoiced the Schmidt campaign, would that be the process that you were asked to look at?
Yes, I mean, it did look like there was that professional relationship that the Schmidt campaign entered into with Constant Content. Constant Content had Strategic and maybe some other subcontractors for some of the services they provided to the Schmidt campaign. But I didn't see a direct correlation. At least I don't recall.
And is it normal when you hire a campaign consultant as in an election that that campaign consultant is equipped to do everything that needs to be done to run the campaign, or do they functionally subcontract that to others?
It is altogether normal for a campaign consultant firm, of which there are many, to provide a whole host of services to their client. Some wrap everything up in one bill. Some may send invoices to pay, for the campaign to pay, for those subcontractors. But either one is appropriate.
Okay, I have no other questions, Madam Chairman. Mr. Hicks here will have some questions. It's Mr. Mayhew. What's your name again?
Kurt Mayhew,
Kurt Mayhew.
M-A-Y-H-E-W.
Okay, and was it correct, did I hear correctly? We've never met before, correct?
Correct.
Okay, and did I hear that you left the Secretary of State's office in 2015, was the year I heard?
I did.
Okay, and what do you do now?
I was asked by a friend to come and help him as he began his term as a registrar of motor vehicles. So I went to the Department of Public Safety under the registrar Don Pettit at the time, and have served as chief of staff at the DMV since June of 2015.
Okay, and prior to that, had you worked at a DMV or?
No. In fact, I was asked to come specifically to bring a fresh perspective on how the DMV conducts its business.
Okay, so but you had no prior employment or other experience with the DMV? Other than getting your driver's license? Like
Aside from being a user, which, I steeled myself to improve the process.
Okay, and with your you had a pretty impressive long run in the Secretary of State's office. It's a pretty different thing from Secretary of State's office to DMV. What was how did that come about? You mentioned a friend or something like that.
Yeah, the registrar, Don Pettit was named registrar under the CASIC, second CASIC administration. I had known Don for some time, worked with him in his role at the Inspector General's office, and he was looking for someone to come in and take a fresh look at how they did, what they did, and whether or not it was even necessary, some of the things that the DMV was doing, some of its processes.
So this case in particular, do you have any personal knowledge of the case?
Aside from the documents that Mr. O'Brien provided to me, no.
Okay, did you talk with Mr. Goldstein?
Never have.
Did you talk with Ms. Schmidt?
Just today.
Did you talk to Mr. Caraway?
No,
Have you ever met Mr. Caraway?
I have not.
Did you talk to R.J. Mancini?
Nope.
Would you say that your testimony today here is an expert, that that's why you're being presented? You don't work,
I think so. I mean, the campaign finance statutes haven't changed much in terms of what, as a regulator, what I would be expecting to see either in the course of the filing or the follow-up audit process.
Okay. Have you ever been a candidate for office?
I have not.
Have you ever been a treasurer for a campaign?
I have, once.
Okay, can you describe that and when it took place?
Again, I served as a treasurer for a friend who was running for township trustee office on the western side of Franklin County.
And that would have been a nonpartisan election, correct?
I believe so, yes.
Okay, so that's the concepts like pre-primary, post-primary, I think apply differently.
Yeah, it depends on when the candidate's name is on the ballot, yes.
So would you consider yourself an expert at the statutes related to campaign finance?
I would believe that's someone else's characterization, but I do know them, I practiced in it. With the book that the Secretary of State's office still has on their website, I wrote, so I do have knowledge.
So my question was, do you consider yourself to be an expert?
I consider myself to be very knowledgeable.
Okay, have you been, other than the one time you served as a treasurer, has anybody else asked you to be a treasurer?
No.
You spoke of
to Mr. O'Brien's questions about how it works for hiring a campaign consultant firm and the services that they perform and so on and so forth. Have you ever hired a campaign consulting firm?
Never.
Have you ever worked with a campaign consulting firm?
No,
Have you ever been a campaign consulting firm?
no.
So can you help me to understand how you would feel that you know how campaign consulting firms work if you've never been one, you've never hired one, and you've never worked with one?
Well, certainly, my understanding is limited, only with respect to how they are billed and how they're paid by campaign committees. In terms of seeing it on the disclosure side, and, you know, if disputes arise, which, you know, they do, between a campaign committee and any vendor, frankly, whether it's campaign consultants or, you know, the person who's making their yard signs, just advising them how to comply with the disclosure statute.
Have you ever been on the Ohio Election Commission?
I have not.
Have you been, or I guess if you're, with all that experience, how often would you say you were a witness in an Ohio Election Commission matter?
This is my first, I believe.
Are you being compensated for your time today?
Absolutely not.
Okay. How do you know Mr. O'Brien or the respondent?
I know Mr. O'Brien as, in his time as county prosecutor. I am a constituent of his, but in terms of Representative Schmidt, I have no interaction.
So when you were in the Secretary of State's office, were you involved in any complaints submitted on behalf of the Secretary of State to the Ohio Election Commission?
I often signed a lot of complaints to the Elections Commission over the years, so yes.
So one of the things that Mr. O'Brien said a couple times here, I don't know if you were in the room when he said it, is he uses the term knowingly.
Mm-hmm.
Can you describe for me, based on your knowledge of the statutes, how the term knowingly applies to the allegations here?
In terms of my understanding of the statute, that, you know, I think the plain language of knowingly, I'm not an attorney, but the plain language would mean that whoever is being referred to, the Elections Commission for an alleged violation would have to have known about. And not just mere knowledge, but I would, you know, other parts of the statute require consent and coordination for certain contributions to be even considered contributions.
Okay, so as it pertains to this particular charge, I'm looking here, can you cite a statute that you think for sure that the actual word knowingly appears in and under what context?
No.
Related to campaign finance. If I told you that election falsification was such a statute that has knowingly as part of it?
I would not be in a position to dispute it.
Okay, so, because actually, what I'm actually looking at is that the term knowingly is in it is in a few places in the statute, 3517.13, which is failure to complete an accurate statement, but it's only in certain cases in that statute, in particular situations. Are you familiar with when knowingly applies to failure to file a complete and accurate statement and when it doesn't?
Trying to recall. I could not recall. I've been separated for long enough. When it comes to, you know, drafting complaints with the Election Commission,
So I don't know the best approach to this, but in that statute that is under consideration here, so in this case, are you familiar with statute 35-17-13 B, C, and D, and what the distinction is between those?
I couldn't tell you today.
What kind of reporting is typically required of a candidate, timeframe wise, or the two?
Well, a candidate, if money is raised and spent by a candidate, you have to have a campaign committee to do that and to disclose through. And based upon the level of activity and the presence of the candidate's name on a particular ballot, then you have pre-election, post-election reports, and others that may be required depending upon what office is being sought and whether or not the campaign committee continues in existence.
So I apologize, I'm trying to read the statute, I'm not being fair to you with your answers. In your answer, did you mention things like pre-primary, post-primary, semi-annual, annual?
Not by name, but yes, those are the periodic reports dependent upon level of activity, office being sought, and the candidate's name appearing on the ballot.
So let's say that a candidate filed a report A and then became aware of an error on the report or something being omitted from the report that they were not aware of when they filed the report. Do they have a duty to update that report?
There is an amendment process,
That's not the question I asked. I asked, do they have a duty to
well,
I didn't ask if there's a process, I asked, do they have a duty to update that report? Yes or no?
If it meets the terms of a contribution received or an expenditure made, yes.
So, just for a scenario, if I said, let's say you ran for office, okay, and I told you, hey, I paid to do a mailer for you, and then I walk away, what's your duty as a candidate in that situation?
It's a good question. I would, personally, I would ask what the value is so I could properly report it, but I'm not sure that that's, that kind of running down of that information is absolutely necessary. Candidates have supporters that do a lot of things on their behalf. And writing a personal letter to friends to advocate for the election or defeat of somebody or an issue isn't automatically an in-kind contribution. Your supporters retain their First Amendment rights to advocate for an election, whichever direction they want it to go.
But isn't there a distinction there between a personal First Amendment right, you being an expert at this, or very knowledgeable, a First Amendment right like I do this, versus I get a group of people together and we do that?
Well, yeah, candidates campaign committee that does that sort of thing would report it as a normal function of their existence.
But I'm just saying, is there not a significant distinction in the campaign finance laws between an individual acting on their own, outside of any coordination with the candidate or any other individuals, which is, I think, then free, that's a First Amendment issue, versus an individual or group working with a candidate?
A group, certainly. I think a group changes the nature of communication. Doesn't necessarily mean that it's an in-kind contribution. They could have independent expenses that a group could make.
So let's say that, but those would still be reportable, right? Independent. By them?
By that group, yes.
Okay. So, but let's say you were running for office and I came to you and said, I'm Chris Hicks Consulting and I get paid by somebody to do consulting services for candidates like you. And then I perform those services and then I walk away. What do you think the duty of the candidate is in that situation?
So you're performing services for me
Yeah,
at someone else's behest?
that somebody else is paying me for. I come to you and I say, hey, somebody else is paying me to do services for great guys like you, so I'm gonna do some services to help you on your campaign. And then when your campaign's over, let's say I just walk away. What duty do you feel a candidate has?
None.
So you don't think a candidate has any legal obligation to due care, due diligence, anything?
I don't think a candidate can control what someone else is doing, especially, again, going back to working in coordination and with the consent of the candidate. Just because you're doing it on their behalf doesn't make it disclosable by the campaign committee, in my judgment.
So you're saying in your judgment, as an expert or close to an expert, that if I decide I want to do this and have somebody pay me and go tell candidates that I'm providing services somebody else is paying me, none of those candidates have any responsibility to any due diligence to try to ascertain what that amount is, what the cost is, or to file any sort of reporting?
It'd be a stretch.
It'd be a stretch that they would have any due diligence, or?
Well, I'm looking at this in practical terms. If I were the candidate, yeah, I'd want to know more about this activity that's going on, but I can't do anything to stop it. I didn't ask to initiate it. It'd be very difficult for me to feel obligated to disclose such things, because I really didn't have any.
Or to try to ascertain what they were?
Well, again, I would pursue it. I would want to know more, but I'm not sure that even if I found out more, that I would have a duty to disclose that activity.
So I want to hit on some particular, so the statute at hand here is, in this case, is 351713. Did you review that statute before your testimony today?
Did I review it today? No. I mean, and not.
Pertaining to this case, did you review it?
No, not specifically, no. I know that those are generally a list of prohibitions in the statute.
Not at all. But so you were testifying here today in a case where those are the specific statutes raised, but you did not review the statute prior to your testimony?
No, I reviewed the complaint and the disclosures that were provided.
Okay. So 3517.13B, and I'm going to read this one and the other two are almost identical, so I can interpolate them. No campaign committee shall fail to file a complete and accurate statement required under Division A1 of this section, 351710 of the revised code. And then the C and D, the only difference is they refer to, instead of referring to Division A1, they refer to Division A2, and then D refers to Division A3 and A4. So what do you think that those mean? No campaign committee, if they need it, I can let you move my computer to see it if you'd like, but no campaign committee shall fail to file a complete and accurate statement required under division, and there's different divisions of these different parts, of section 3517.10 of the revised code.
That they have to file a true and accurate statement of the money that they raised, the money they spent, the other contributions that they received as part of their overall mission to get their candidate elected.
So, just by comparison, part of this that is not part of this case would be section E of that same statute, and it reads, no person other than a campaign committee shall knowingly fail to file a statement required under section 351710 of the revised code. And that's fail to file versus complete and accurate. Okay? Being that you had all this experience, why would you think the legislature would have certain parts of this actually have the word knowingly and certain parts not have the word knowingly?
I have no idea.
But you would agree, I mean, I could, like I said, I could give you my computer to look at the statute. The BCD where I read B and then just told you that the word knowingly doesn't appear there, so no campaign committee shall fail to file a complete and accurate statement required under division A1, section blah, 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 of the revised code. Would you agree that the word knowingly is not in that part of the statute?
Take your word for it.
Would you like to look at it on my computer? Okay, so why would you think from a policy standpoint, the word knowingly might not be included in is not included in those pieces?
I don't know.
Do you think one reason might be that it would prevent candidate rope-a-dopes to say, well, I didn't know, so I didn't have a duty to do anything?
I have no clue.
Do you think that a culture in which candidates could just say, I didn't know, even if the person told me I'm doing compensated professional services for you, I didn't know, and then take no steps to ascertain? Do you think that that would be good public policy in Ohio? Let me ask that first, and then I have a second question to that. Do you think that's good public policy?
I'll leave it to the legislature.
Well, do you think that's consistent with the statute? The word knowingly is not in the statute, so do you think that that is consistent with the statute, that a candidate can say that that it's okay that I didn't file a complete and accurate statement because it wasn't knowingly? Even though the word knowingly is specifically not in those parts of the statute, but in other parts of the statute.
I don't have an opinion on that. I mean, ultimately, it's going to be up to this commission to determine, but.
Well, you're here as an expert on these matters, to help the commission.
Well, you know, from what I've seen of the three things that the complaint, the original complaint, as I read it, I'm here to say that I don't think that the Schmidt campaign failed to file a complete and accurate statement. I don't think that they accepted a corporate contribution. And the third one's not coming to me, but of the three things that are alleged, I don't see how anyone could conclude that they violated those statutes.
Because you don't think that, for example, R.J. Mancini, that there's anything that should have been shown as in kind for him?
He was paid, right, by the ORP. That was in kind to the House caucus. The caucus exists to get members elected, and they hire a lot of people. Do I think that they have to delineate to the dollar every person they hire to a particular campaign committee? No.
Is there any statutory basis for that statement? I'm not aware of any, so I'm wondering if you're aware of any statutory basis that you can have compensated people but not delineate them to the campaign.
Well, it'd be similar to going to Walmart and buying some things. Am I going to get the hourly wage for the people who stocked the shelves, who ran the checkout to produce this receipt that I paid for out of campaign funds? I mean, at some point, the existence of the caucus committees is to get their people elected or re-elected. And they hire people to do that. If the legislature wants that sort of delineation, they could enact statutes that would require it. I don't know of anything that would require that kind of dividization.
But I'm confused by your Walmart example. If I went to buy something at Walmart, if I put it in campaign context, if I were door knocking as a volunteer, there's a big difference between that and I'm door knocking because I'm being paid. And if I buy something at Walmart, the notion, I don't understand the basis of the example that maybe you thought that, somebody could maintain that, I should figure out what the employee's cost is that stock the shelves.
Hey, you have a campaign volunteer at a parade, they go buy a lot of candy to pass out. Does that all of a sudden wrap Walmart up in some sort of vast
Well, but
itemization?
if the campaign volunteer bought candy at Walmart and the candy cost $100, okay? Is not that something, the $100, something that the campaign is obligated to in kind?
As soon as they're aware of it, yes.
Okay, so what does that have to do with the wages of the people stocking your shelves at Walmart?
Well, Walmart's a vendor. In this case, I think the Ohio House Republican Campaign Committee is a vendor, and, a very intimate vendor with their clients, their candidates. But again, if the legislature wanted that level of detail, they get required it. And I don't know of anything that compels the caucus, the party, or a campaign committee, they'll provide that level of detail.
Well, I'm looking right now on my screen, I'm glad to show it to you, the campaign finance handbook, and it says you have to have that detail. So it says anything of value other than my blah, 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 we can pull this up, we don't have a screen here, but it has to be reported.
I think the Schmidt campaign reported in-kind contributions from the caucus. But even if they didn't, I think the caucus has a duty to elect its members.
So that duty would mean, since they have a duty to elect its members, they don't have to follow campaign finance rules?
Well,
Jack, that isn't what you testified to.
yeah, and
Well, you can clarify
and I
what you
don't know
exactly
that-
just said.
I don't know that, at least in that particular case, Mr. Mancini was known to be working for the Schmidt campaign. I would have to defer to the candidate or her campaign committee.
Did you review the testimony from prior hearings of this case?
No, just well, I did see the testimony from Secor. But my focus was the complaint and the exhibits that were provided.
But you saw that by video, watching the video of the hearing or something, or?
No, I saw a printout.
I don't believe there's any transcript for this hearing thus far.
Well, maybe I'm, oh, yes, the affidavit. I didn't watch it, maybe an affidavit.
Did you seek to talk to Mr. Secor
No.
before coming to today? Okay. In that blue book behind you there, this is blue, those are different exhibits.
I've got about 10 minutes.
So there's little white tabs that are different dates. One has an error, but it says 7/23. And that right there where that 7/23 tab is, there's an exhibit A. And then back in the back of this, there's where it says RESP, which means respondent. There's exhibit 11 back there. Each of those are invoices from Constant Content. Are you able to locate those? So one is exhibit B, that's under that tab that says 7/23, it's the very first thing, exhibit A, I'm sorry, exhibit A under that tab. And the other one is exhibit 11, which is the invoice for, which is another invoice. They look the same, they're just way different amounts and line items.
Yeah, so 11, okay.
So one is exhibit B, which is the $39,000 invoice, and one is exhibit 11, which is the $164,000 invoice. The $164, I believe, was paid in full. A part of the 39 was paid. You, in your testimony, said there were things that were already paid for or double paid? Maybe you could explain to me what you're talking about.
Well, I believe what I was looking at was, so there were two invoices, 1127 and 1102. 1102 was fully paid. 1127, I believe, included one or more of these SCH 0012 and or 3. So it was, I believe they were, I think they were double invoiced, a couple of items, which factored into what I think Mr. Goldstein was trying to collect on, and ultimately had to reduce that invoice from 39 to $20,000 or so. And I think it's because some of those things were double billed.
Can you cite the line items on invoice 11 that you think were double billed in on the invoice in Exhibit A?
Okay, so on Exhibit A, the last page of Exhibit A, he's referencing, this is the initial invoice 1127. He references 001, 002, 003, 004, 5, and 6, and 7. So all of it is wrapped up in there. And then,
Well, give me just one example where you think it's double billed.
well, on 1102, so this is from Exhibit 11, SEH 001 and 002, they're separately itemized there on 1102, but on 1127, they're kind of put together for $10,000.
I don't see that. I see on the invoice number 11, an item SCH 002. On the invoice Exhibit A, I see SCH 002P.
Okay. I'm assuming, well, I don't know that there are different.
So you didn't notice that they were actually different numbers until now?
Well, the addition of the P, I don't know if this has something to do with Mr. Goldstein's method of billing clients as a debt collector. I don't know, I'm just saying.
Well, the invoice Exhibit A, is that from Mr. Goldstein or is that from Constant Content?
Well, Exhibit A is a letter from Mr. Goldstein.
But the invoice portion, who is that from?
That is from Constant Content, provided, 8 months difference.
But do you have personal knowledge that that invoice was not provided to campaign proximate to the date of 11/4/2020 that's on the invoice?
Yeah.
So you have no personal knowledge that they maintain they didn't receive it then, but do you have any personal knowledge that they did not receive it on 11/4/2020? Or thereabouts? Okay, so can you go to Exhibit S, which is, there's a little tab coming out on that book that says 1026, and that page is Exhibit S. We'll start at the beginning.
I see.
So can you read the very bottom of like that? Down, see that mailer, it's a copy of a mailer, down at the very bottom, there's a number down there. Can you read that number?
You need to be around, we need to stop there.
Okay, we're gonna have to take a 5-minute break. Sorry.
Okay.
I mean, this is do like a bio break. So, we'll come back. in 5
Chairman's
minutes.
break.
Well, I've got to go, so
Otherwise.
we've got a hard break, so.
He's got a hard break to feel too.
Yeah, I've got to go. I mean, I'm happy to come back another time.
Oh, no.
How much longer do you have, Mr. Hicks?
No, I have
However
zero
long
time.
it takes,
I
I
have
want to
zero.
go through these things, and I'm not gonna
So you're,
subscribe to this
that you're not
specific
leaving
timeline.
because of me, because I called it. If I
No.
have 5 more minutes, could you sit there for 5 minutes?
No, I was getting ready to say, hey, I've got to split, so.
And at least that's not that, I mean, 15 minutes ago, he said he had 10 minutes.
I understand, but I don't wanna,
Yeah, I need more time, I need time with him until I'm done questioning.
Well, and I think the chair asked how much time.
do what?
I think the chair asked how much time, and I didn't hear an answer.
I think that depends on his answers to the questions I'm asking.
Just let me know. Thank you.
It's not my witness, it's his witness.
He had the hard break and,
All right, I guess we're back in session.
He left.
I don't know if he
He left.
No, I
He
didn't,
left.
but I mean, like,
He just left, but he's not coming back.
no, I
Well, he
understand.
said he would come back, but he's not coming back now.
Yeah,
I don't know if
that's
he's parked at a meter or.
No, I understand,
Yes.
I just need to know where we go from here, because I feel like, and, 2.5 hours for people not to be able to get and go to the restroom is kind of
No,
pushing
no.
it, but there's not been a good stopping point, so where do we go now?
Well, why don't we take the break that you just asked for, and then we can regroup, because he's not here and he's not going to be back, and we can figure out after this break.
Okay,
Take your break.
5 minutes. Sorry.
Sorry.
Glad you said something.
Well, just, good lord.
It's certainly not my preference, but I'm not sure what other options we have. Right now, so aside from reconvening at a future date. It can't be next Tuesday or Thursday. I don't want to do it next Thursday. It would have to be 16th or 30th for the next two available dates. That's all I can, I can't, I wish I could say something different, but I can't. 16th, the next two meetings, the next three meetings are the 2nd, the 16th, and the 30th. And I don't want to do it next week. Okay, for commission reasons. 16th is a possibility. We have my total agenda for the future.
Okay, back in session.
Well, I mean, presumably Mr. Hicks has additional questions he wants to ask about witness. We would need that witness back. I would not suggest bringing this matter back on the 2nd, which is next Tuesday. The next two meetings after that are November 16, November 30.
At least I might add, Mr. Maybe was waiting patiently in the hallway from 11 a.m. this morning and said he had a hard hood around 3:30, and he did indicate to Mr. Hicks at the 10-minute mark. And as he also testified, he's not being paid to be here.
So this has nothing to do with this, you still have witness and I still have questions.
But, relevant questions would be helpful in moving things along.
Well, I guess that's start a different version of justice in America.
So you can't move forward without continuing?
No, I want to continue to question him. I think it's absurd that I'm somehow
Okay,
the
well,
bad.
no.
He made a comment, so I want to make a comment, that I'm somehow the bad guy because he arranged an expert witness that had to leave at 3:30.
Who was here at 11 a.m.
Okay, okay.
Yeah, obviously,
I-
I wasn't gonna
okay.
testify at 11 a.m.
We get it, okay. So I guess what we're looking for now is what date can everyone come back? It cannot come to the 2nd. So what date between the 15th and
16th and 30th.
16th and 30th? Will you please look at your calendars and see when you're available to come back?
Does it matter until we find out when the witness is available? I mean, we
Well,
can
I
all-
just,
we can all pick a date, and then that witness can't make it, and we just wasted another 5 minutes of date discussion.
yeah, I just texted if you didn't answer, if you.
Can we just get when they're available, because I
Yeah,
know there are
do
times
either,
when.
right, Ron, do you or Mr. Hicks have a conflict on either one of those dates?
Yes.
I have a conflict on the 30th, I do not on the 16th.
What day of the week is the 16th?
They're
They're
Thursdays.
They're all
Thursdays,
Thursdays.
yes.
I don't think I, no, you don't.
Yeah, I do have a problem on the 16th.
Okay, so you have a conflict on the
On
30th,
the 30th.
you have a conflict on the 16th,
And we're off to December 14th.
I don't
No,
know.
I would have no aversion to like the day before another meeting or something, just to get this over with. We tried to do that before, we were gonna have 2 days, but that didn't pan out.
December 14th, I don't have a conflict.
What day of the week is that?
It's a
it's always a
Thursday.
Thursday.
29th then,
Thursday.
since you're
You do have a conflict?
29th? I'm asking, I
The
don't know.
29th of November,
Yeah,
that week is very bad for me.
It's the 30th.
okay.
Oh, the 29th since it's.
So that week, that particular week of November, I put some volunteer activities on my, so
I can't do the 29th.
What a shame, you could have celebrated my birthday.
Okay.
This wouldn't be a celebration?
Oh, gosh, I
I'll bring
don't
the
know.
Yeah.
I'm gonna celebrate when we're done, I'll tell you that. We got the Christmas party too, to
I know.
figure out,
I know,
Madam
that's-
Chair. That's
I know.
important stuff.
I know.
So do we know which one of those various dates I should check with him?
Are you okay on the 14th?
You're on-
Ron, are you okay on the
Everybody's getting a little
14th?
Debbie's
Of
Christmas
December, yes.
cake.
Oh, on December.
do.
December
Yeah.
14th.
Oh, jeez.
I second.
Unless potentially the 15th of November. I mean, if you talk about doing a day before a current meeting.
We make sure we don't have voting session, please.
Yeah, the 15th.
I would love to get it the 15th or the 16th to get this over with.
What about, the, Friday, the 15th of November?
That Friday would be
That's
the 17th.
17th.
Oh, 17th, Friday the 17th.
I have no conflict on the
Or
17th.
the 9th, November 9th, which we
No,
don't have a
I'm-
meeting yet right at the moment.
I'm out of town.
I think the thing, if I were one of you guys, would be like, if you're gonna do a separate one, I'd do it like at 1, get it over with, and then you have a morning meeting at 10 the
No,
next
that's okay,
morning.
he said he couldn't do the 30th either. Or no,
What did you say? I'm sorry, Mr. Hicks.
15th.
I was just saying, procedurally, if I were you guys, I'd rather do it the day before one of your meetings, because then you could do it even in the afternoon, get it done with, and then have your next meeting in the morning the next day. Versus if you do it, your meeting next day and it ends at like noon or 1, and then you have to wait around for a day or go home and come back. I think there just might be some logistical stuff, but I'm just game for any, I think, I don't know,
So the 15th, there's no conflict for anybody on the 15th?
November 15th?
Yes.
Yeah, there is for me.
I have a board
Okay,
meeting.
November
for my-
15th is a Wednesday?
Yes.
Let me please call.
No,
November 7th.
I can't.
we're talking
Oh, you
about.
can't do
Commissioner
it.
Knight cannot on the 15th.
and Brian
Friday.
said he can't.
No,
What about the 14th?
17th.
Now
No,
we're getting
I'm
into
not in
The
conflict.
17th, which is a Friday.
17th, are there conflicts on the 17th?
I have a conflict.
Okay.
Okay. We can't do the 24th because it's Black Friday.
No,
The day
you
after
can't.
Thanksgiving.
The 23rd, you have your party, your combination
Yeah, that's my
Thanksgiving
husband's
and.
birthday, and the Thanksgiving combo, he is in high heaven, so.
Oh, that's Thanksgiving weekend.
Yeah, the 23rd, 24th.
Oh, yeah,
I mean, I'll be here, but
oh, yeah.
I don't know, what did he say?
We have to, Vice Chair Tavares, we have to consider that she may have conflicts as well. We didn't think about that.
can we call her?
Not at this point.
No.
Could we throw a tentative date, and if it doesn't work, then we have to re,
So far, we
Wednesdays,
don't have a good tentative date where nobody has a conflict, other than.
What about December 1st?
Or this, yeah,
What day of the
first,
week is that?
7th,
That's still part of that week where I'm busy that whole week.
December 7th?
The week of the 27th through the 3rd, December 1st. That's a
Okay,
really
so
bad
then the
week.
next week is December 7th. Is anybody available on December 7th?
what day of the week is that?
It's a
Thursday.
Thursday.
Okay, I should be okay.
I'm not.
He's-
Monday and Friday that week I am, but not Thursday.
Okay.
Is there any, your thing about next week, I know you said, Phil, you didn't want to do it next week or whatever, but,
I am not going to be here. I'm
Oh,
going to
okay.
be working out of state.
okay.
When do you come back?
I'm coming back on the 6th and I leave again on the 9th,
What day of the week is the 6th?
Monday.
Monday.
Can we do it on a Monday?
I can't, I'm not here until I can fly in literally into Columbus at like
Okay.
6
What about the
o'clock.
7th?
Can we do it at the airport?
Seventh's election day.
Oh, yes, 7th election day.
Can we do it
sorry.
remote?
No.
I knew the answer to that.
What, the 8th? I
Nice
would be
try.
able on the 8th, because I know we're not having session on the 8th.
Nice
Peter,
try.
you need to call people.
Set up the TV and watch Ohio State, Michigan and do it. I don't know.
How about the 8th?
What month are we in now? I lost
November.
track. November 8th?
It's a Wednesday.
November 8th is good for me.
That's the day after the election?
Yeah.
I think that's good.
I have a board meeting.
At what time?
A board meeting is in the Cascola at 2 o'clock.
Can we
So,
start at like 9 o'clock and hope that it ends? So how far away does Patasko?
oh, from here, it's like, it's like
Is
25
this-
minutes
is
from
this
here.
the-
From where I normally go, it's more like an hour, but from here.
So, you just have a hard stop at 1:30?
Or is this a sole
No,
witness?
I would not, I would be remiss to show up like as the board
Board
meeting
Because if
starts.
it's just one.
It's your
I
vote.
would, I would
Tag
be
it on
stopped
next
by
Thursday, just-
1.
I need
Maybe
to
we chip
stop
away at those things.
By
anyways.
11:30. I need to be
Have
somewhere
provided
that day.
these and-
That's a good idea.
Why don't we keep chipping away at this thing, whatever it takes, like next Thursday, we throw it on the schedule, whoever shows up, no offense, everybody, whoever can come. I know you both have to be here, but is
mean,
next
if
Thursday
you don't mind me
completely
not
out,
being
other than
here,
our agenda?
Well, that's,
Oh,
At this
well.
point, I'm okay
Do
with
we have
not
a
being here.
quorum?
Well, but for a full vote, we
If
need.
you want, you guys can quorum without me, I'm not kidding you.
At this point.
Mr. Richter, has, yeah, I have to be
My
here.
fault.
It's only because we potentially already lost one meeting.
Yeah.
What about tomorrow?
I have a nail appointment, I'm just kidding. I do, but I could change it.
I wish.
I can't do tomorrow.
Yeah, I can't get it more.
December 21, we're getting closer to Christmas.
oh,
How about December 18th? It's a Monday.
so those 2 weeks, the week of, that week and the next week, I would, right now, I'm not gonna be in Ohio.
The 21st?
It's 11, December 11.
It's my birthday then. Thank you.
I'll make you a cake. What kind do you like? I make scratch cakes.
I just like.
I mean, with no box involved. It's
I know. I
butter,
did.
sugar,
That's
all
good.
You'll
that
probably
stuff.
talk about that one, right?
You guys are the 11th or good?
December 11th?
The week of
Okay,
December 11th,
you're
or
the
you?
11th?
As long as you don't make it a Wednesday,
I
because I
just
don't know
wanna
whether
say
we're gonna be in
something.
session or not.
I'm fine with this, but it should be noted for the record that December 8th last year, we were in a Blystone case on my daughter's birthday, and on the 22nd, which is my anniversary, we were in a case for the Blystone case. I will do whatever it takes, but I want this to be noted historically, that
Have we
it's
checked on it?
sacrificial love.
Have we checked on that lately? Are they gonna actually go to like call them about that?
Good question.
Don't bring that back up.
Yeah.
So,
December 8th or 11th, or is that where we're talking?
Both mine or my daughter's birthday,
He's
sounds
out there,
great.
he's out there.
Can we do
Somebody
my
else
birthday?
is
so the 11th
12th.
is really the only day
Yeah, that's fine.
where everybody is available the 11th, with the exception we don't know about Vice Church of Ours.
And the
Or witness.
Phil, I'll call the witness right now. and
Yes,
find
please.
out. It's on Monday, December 11th.
One
You need to
second.
text him first and all caps, pick up your phone.
I'm pretty sure I have a board meeting on December 12th, so you guys are really, that's tough for me.
I do have a board meeting on December 12th.
Oh, I have an air appointment on that.
So you can feel
Do you
my
have one
pain.
ED?
I have a hair appointment too.
I also am the ED.
Considering where we are on this, I had to throw that
If I
out
don't
there.
get
Great Clips ain't gonna like let me just, walk out without,
I had to throw
out of
that
that
out.
appointment.
Listen,
As an aside,
Kurt,
as an aside to these discussions,
on various dates.
I think people like me and her and witnesses, technically by the statute, they don't have to be in person. The board needs to be in person. And so it came up before in the olden days when Kreitz was the chairman about enabling for witnesses and respondents and complainants to appear virtually, which is not statutorily legal.
again, but I just.
The witness is available Monday, December 11th, he said.
there we go. What time? 10 o'clock? Do we want to?
6 a.m.
6 a.m.
Again, you got informed without me.
That would be a little difficult unless you want me to bring the dog.
I do want you to bring the dog,
Yeah,
actually.
that's all right.
Should be a great distraction.
Yeah, we want a baby and a dog.
Not 6 a.m., I think.
So do we want to do 10 or do we want to do 9?
I'm
Ten.
here much earlier than that. Then we're talking
She's
about.
freaking out.
how
Columbus,
our
I mean Cincinnati,
Representative
Cincinnati,
Mr. Hicks,
right?
Ms. Hagan, Mr. Stalper,
I
Mr.
was
way
way
up
up
north,
north,
way up
yeah,
north.
just kidding, I have no idea.
I mean, so I'm not one to say when to start, only because
I need to ask her.
it's irrelevant to me. I'm here.
So 10
You would
o'clock?
presumably be available as well.
I say we keep it consistent.
Yeah, that's good.
So, at this point,
Yep, that's what
Okay,
we're doing.
at this
I have a
point,
question.
yes,
Do we
ma'am.
know about approximately how many witnesses remain?
Yes.
Well-
Is this a 1-day meeting, is this a 10-day meeting, 2 hours,
That'll
40
be him.
I think
hours?
enough is enough, we're gonna stop this.
I mean,
I don't know,
We
the
say that
only
every
witness I
time,
might
though,
have in
before.
addition to Mr. Mayhew is I may recall Ms. Schmidt, but that would be the only other witness I have.
So, Mr. Mayhew, potentially Representative Schmidt, who will be here.
Right.
Could we just, no, okay.
Well,
Yeah,
we're,
yeah.
no, okay. So, you feel good about that?
December 11th?
December
Yeah.
11th at 10. One witness, potentially recalling Ms. Representative Schmidt.
Yeah, I've done my case, right?
yes.
So,
Okay, so this case will be continued till Monday, December 11th at 10 o'clock. And so that's where we're at with this case. Do we need a motion for that, or?
No, I think you just declared that. Presumably it will be here, but I don't know the answer to that. We'll have to have, either I or Chris, either I or Chris will have to discuss with
I have a
where.
conflict on the 11th, can we make it?
No.
No, I have a conflict on the 11th, I just checked, and it's personal, and it can't really be changed. So,
Is it time,
no, no. And it has something to do with my husband, and I just checked, and I make things on Mondays and Fridays because I'm usually here Tuesday, Wednesday, and Thursday. So I can, and the 12th, I can maybe bleed over into the 12th, and so I'm just asking, can we do it the 14th? Or the
That was
13th?
raised as a possibility, somebody else had a conflict.
Yeah, we went through 12 dates.
Okay,
Oh,
I
yeah.
can't help it, I cannot help it.
Let's just go ahead and.
I think-
vote on that. As
Well, I
Monday,
didn't know.
we go into the hours of the night, just
December
like session
14th, we
here.
have a
We have a
regular board.
Just go like
But
session.
someone had it,
They
they
want
had
it
it
just
Mr.
one and
O'Brien.
done.
Oh, okay, got it.
You can't come on the 14th
I thought you guys
No,
were.
no,
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 we're
Mr.
talking
O'Brien.
Mr. O'Brien.
specifically.
no, I can come on.
Mr.
No,
Mr.
December,
Hicks, you're
now
out
we're
of
talking
town.
December 4th.
December
Are
14th,
you
correct, I
okay?
can be here December 14th.
Oh, you can.
I think Mr. Hicks
I
said.
thought Mr. Hicks said
we
we
can't.
can't.
He said he had
Oh my
problems
gosh,
the
then
whole
why are we
week.
doing this?
What? Doing what? He can't come that day? Wait, it does work or it doesn't?
Not in the,
I said the week of the 18th and the 25th of December.
Yeah, he's
I'm not-
out.
Yeah, that's what I said, not the
So
14th.
December 14th, everybody can be here.
This
This case is continued until the regular meeting of the Ohio Election Commission on December 14th of 2023.
Okay.
Should we be here in the morning or the afternoon?
To be here at 10.
Well, we're gonna be the first case.
And you'll have
No, there will be some other matters on the,
But I would not, I wouldn't, I'd just be here at 10. And that's what time the meeting
We're
starts?
on 11 o'clock.
Okay, we're 11.
You send out the agenda, that's when they show up.
Well, I mean, but,
right now there are
Mr. Mayhew,
two,
as long as he-
oh, it's Mr. Mayhew couldn't come on the 14th.
Yeah. Well, that,
No, just for his, just to have him at 10.
yeah, I didn't, he didn't give me any no dates, he just said that he could be here the 11th, let me see.
okay.
Oh, so the 11th, so we're okay.
There's only, right now, I know we have some campaign finance cases, we're in the process of sending notice out for those.
Yes, their regular meeting is on Thursday, December 14th, and that
Which
would probably be
has gotten
10:30
taken to the
to
current
11,
time.
does that work?
I'm done for the day.
Okay, okay, good.
You mean you're
I'll talk to
not
you,
still
Okay.
working in there?
When this happens,
Now, Mr. Mayhew says
get your night out.
December
Or,
14th.
no,
Mr. Mayhew's available on December 14th at
okay,
10.
we'll see you all then.
Or I told him 10:30.
That should work.
Okay, sure.
Thank you.
All right, the only matter left on the agenda is, the next meeting will be on
Second.
November 2nd
That's correct.
at 10 o'clock, not 10:30, not 11, 10. So please be here then. Do I have a motion to adjourn?
Even if the chair's not gonna be present.
So moved.
And we have a motion on the floor that's been duly seconded. All in favor, signify by saying aye.
Aye.